Item number 1.
My lords, we appear on behalf of Kesram Industries, the award debtor.
Reading the ordering portion. Accordingly, APCOM 334 of 2024, APCOM 335 of 2024, and APCOM 563 of 2024 are disposed of, thereby setting aside the impugned award to the extent of claim number 3, Roman 3, to the tune of rupees 127 crore 12 lakh 64,892 towards future commitment charges, and also modifying the award to the extent of counterclaim number 2, inasmuch as the interest payable on the mobilization advance from March 2017 till the date of the award is to be calculated not at the rate of 9% per annum, but at the rate of 14.50% per annum. The said award accordingly stands modified to such extent. EC 335 of 2023 along with GA Com 2 of 2024 shall now be placed before the regular bench having determination to take up such matters. Liberty granted to the parties to mention the matter before such bench. No orders to cost urgency.
Deeply obliged. Lordship, only one indulgence, Lordship. We had secured the arbitral award by furnishing FDs by way of the order on 7th May 2024. Lordship, a specific direction for release of that sum?
No, make that prayer in connection with the EC.
Where?
Because that's still pending. So make that prayer there. Next.
The EC to the infructuous or here?
What happened?
Did the 127 is set aside? I missed that part.
I've set aside the future commitment part and modified the interest on
14.5.
Yes.
So the EC does not get infructuous.
No. EC, I have said that EC will appear before the regular bench. And I have, he prayed for, your learned friend prayed for withdrawal of that amount which has been deposited. I requested him to make that prayer before
the EC court.
Deeply.
Ordering portion. In view of the above discussions, GA3 of 2024 is allowed, thereby impleting the heirs and legal representatives of the deceased original award debtor Aditya Vikram in terms of prayer made in GA3 of 2024. Necessary consequential amendments to the execution application shall be carried out by the department within 4 weeks from date, including all formalities of reaffirmation. In view of the above, this court turns down the objection as to limitation, and it is hereby held that the execution case bearing EC such and such is within time. Objection as to the execution case being time barred either as a whole or only against the omitted legal heirs of late Aditya Vikram is hereby turned down. The execution case shall now be placed for hearing before the appropriate coordinate bench currently having determination to take up such matters. Liberty is also granted to the award holder to take out necessary applications and or to seek amendment to the tabular statement execution application for incorporating further reliefs in the light of the observations made above. I made certain observations because those are incomplete prayers in the light of there no orders to cost urgency.
That liberty lordship has given us too.
That liberty I've given you to make in the execution case because I've discussed previously what are the according to me what other prayers might have been made.
Absolutely. Grateful, Murad.
Thank you and sorry.
Grateful.
Next.
I'm for the petition, my lords.
What is the contempt?
The court fixed the matter on 13th of November, my lord.
Yes, because of the change of determination, the difficulties. So, should I direct this to appear Friday week?
As you
I mean, Friday week because next Friday is a holiday. So, I'll take up only on Fridays. No personal appearance.
No, my lord, there is not.
You are for the petitioner.
I am for the petitioner.
Very well. Learned counsel for the point that the matter was scheduled to be taken up for hearing on November 13, 2020 and is appearing early. Full stop. Since this bench is now taking up these matters only on Fridays, comma, and the next available Friday is November 22, 2024, comma, let the matter be listed under the same heading on November 22, 2024.
I'm grateful.
Mr. Shah, November 22nd.
My lord, I'm in the next matter. I'm sorry.
Oh, I'm sorry. Yes. 7.
This is also an application for contempt.
Right.
My lord, the appeal against this order is appearing in the list of the Honorable Chief Justice today as item number 10.
Very well. Then I'll keep this also on 22nd.
I'm so grateful.
Friday week. Friday. Since the connected appeal is the parent order is now pending for adjudication before the concerned bench, comma, For the ends of justice, let the matter stand adjourned till November 22, 2024.
I'm so grateful.
Yes, yes, Mr. Sharma. Use the microphone, can't hear.
So Bose is appearing this matter. He's not in town today. I'm paying some
Mr. Sharma, the difficulty is because these matters I'm taking up only on Fridays.
accommodation.
One day means it goes to 22nd then. On the prayer of the petitioner, the matter is adjourned till November 22, 2024.
Lordship, can it be on 29th? 29th. 22nd, I have personal difficulty.
If they subject to their consent.
My lord, item number 9, my lord, any day convenient to the court.
Very good, very good. তাহলে যেটা বললাম সেটাই থাকবে শুধু নভেম্বর 29th 2020. Thank you, Mr.
I'm so good. Item number 9.
Your Lordship, I'm paying for, Your Lordship, on behalf of the petitioner, I'm paying for not to be Your Lordship.
But this bench is not regular.
Your Lordship, it is difficult for.
The petitioner seeks an adjournment, let the matter stand adjourned till November 22, 2024.
Your Lordship, 10 also, 9 and 10.
10 same order.
Deeply obliged, Your Lordship.
Item number 11.
Regard to item number 11, my lord, I appear for the respondent.
Yes.
No, there were two applications under section 34, my lord.
Since this is a broken bench now, I'll request all of you to be brief and come prepared with the written notes of arguments as soon as possible.
My lord, it came suddenly, my lord. I was also, after 2 months, I think it was last heard. And
Yes,
your
just
lordship has...
remind me the points, because detailed hearing ultimately will take us nowhere.
Yes, my lord.
Touch the points, remind the points, and just make your arguments, and I'll hear them then, and then ask you to file a written notes of argument someday.
Lord, can I pray for a short passover, my lord? My brief is...
Passover. Next.
Lord, same, my lord. Same, 11 and 12, my lord.
11, 12, Passover.
My lord, I appear for the award holder, my lord. I'm the respondent in the section 34.
12.
13. 13, my lord. My lord will recall the petitioner's section 34. I'm the award holder, my lord.
They are still arguing the matter.
My lord, they are still arguing, but they were only to cite certain judgments. My lord will recall this is that case, my lord. May I just remind, my lord, of the point?
Just pass it over. You try to inform them.
We'll try to inform Mr. Jain.
Because I have this bench, limited bench. So Passover.
My lord.
Just try to inform them over the phone or whatever.
Call to Mr. Jain.
My lord, I am for the respondent.
14, my lord, I appear for the petition.
This matter I had mentioned before, your lordship, when your lordship was sitting in the division bench.
Yes.
My lord, Mr. Shah is in difficulty today. Jishnu Shah.
My lord, we are ready, my lord. We can continue because lordship would.
We'll do that. I'll hear him, and then if he concludes, then
We can start.
I'll keep it on the next.
Yes. Lord, lordship would kindly take the notes that we had handed over on the last occasion. There's a small 15 pages notes of argument which contains the points that we had argued on the last occasion. It was heard on 14th of August. Lord,
Did they also hand over written notes? No.
No, my lord.
Written notes stuck to the right.
Lord, I will conclude very quickly, my lord. Your lordship.
Yes. I'm sure of that.
No, Lord. Lord, a brief recapitulation, because it's a technical matter, my lord.
Yes.
Lord, the metro railway tunnel was to be built. That's the contract. Now the metro railway tunnel is built by a tunnel boring machine, which, my lord, moves. My lord, looks like a rocket, and it moves, my lord, underground. Cuts the earth in front. It's got cutters in the front. It cuts the earth, and my lord, the soil goes out.
Journey to the center of the earth.
Yes, it looks. I've seen pictures of, my lord, a tunnel boring machine. In fact, they are on record. It looks exactly like one of those, my lord, rockets in
furnace.
those 1970s
Yes.
USA, USSR movies.
Yes.
Now, my lord, it is expected, having regard to the situs of the city of Kolkata, that water will be encountered below the surface of the earth. Now, different kinds of water. Now, it may be silty soil, which is, my lord, soil inundated in water. It may, my lord, be clay silt. It may be sand which is inundated. It may even be a water table. A water table, my lord, is a void in the earth which has, my lord, water accumulated within it. The tunnel boring machine is designed, my lord, to go through water also. In fact,
They were given the contract and it's their machine.
It's their business. They are, sir. The entire design is by them. The TBM is chosen by them.
Right.
TBM is acquired by and brought by them. Now, this, my lord, has to go. So, my lord, it can go through water as well. It can withstand pressure, water pressure up to, my lord, 37 bar, or, my lord, there's a mathematical calculation, which it is nobody's case, my lord, with certainty that it was exceeded. In fact, it can only be exceeded if the water pressure is so high that, my lord, there's, my lord, water traveling, my lord, from top to the bottom. That, my lord, increases water pressure. So even if it goes into a water table, there's no problem with the TBM.
Horizontal.
Yes, it goes
Mostly
horizontal.
horizontal.
Yes. And as it goes forward, my lord, from the middle towards the end, my lord, concrete rings also come out and they form, my lord, the tunnel. So it goes forward, it leaps forward is the expression of the engineers.
Bolsters the.
Yes, it cuts the what is in front of it, which goes out, my lord, through a cable trough, and rings are, my lord, fixed.
Yes.
And it, after each ring is, my lord, built or, my lord, released, it leaps forward, my lord, maybe 2 feet or 3 feet. And then or, my lord, the size of the ring, and then the next ring is built. And it keeps spraying, my lord, grout and concrete to ensure water doesn't come in. Now, there are not 3 places where, my lord, a water can enter into a tunnel boring machine. The first is, my lord, from the front, where, my lord, the cutter head is. Second is somewhere in the middle. And the third, and which is the easiest place for water to breach, are, my lord, the tail seals. They are, my lord, known as tail seals. Now, to ensure that tail seals are not breached by water, my lord, there are brushes, my lord, on the side. My lord, these brushes, I've seen, my lord, one of them. These are huge toothbrushes. My lord, the brushes are of wire, my lord, steel. And they will not grip the side of the tunnel. So, my lord, the tunnel boring machine is here, the brushes are here, and they grip the tunnel. And the system is that grease is pumped into these brushes. Grease, my lord, attaches to the brushes and creates, my lord, some form of a situation from where, my lord, it's, my lord, it moistens the brushes. A, it protects the brushes from abrasion against the concrete and the side. And B, it's thick. So, my lord, between the brushes, it fills the void and no water can come in. So, the ideal situation is, I wouldn't say utopian, that's how it's designed to function. The ideal situation is grease in the brushes, adequate quantity, full brushes. So therefore, no amount of water will come in and penetrate. Now, this is, my lord,
What is the function of the brushes apart from that, apart from preventing
nothing,
water?
just to prevent water from coming in.
All right.
Or whatever is in front, because, you know, the TBM, the TBM actually goes into whatever is there under the earth.
Yes.
It may be water, it may be water table, it
Brushes
may be
are
ground.
there at the front, at the side
the
of
back.
the front.
At the back. You know, if this is, my lord, the TBM,
Yes.
you know, the brushes are over here.
Okay.
So I'm sorry, my lord.
Yes, yes.
The cutter is here. So it cuts, the earth goes out, and the brushes are here. So it will never, my lord, water will never breach into the brushes and the rings get, my lord, erected. and it keeps moving forward. The crux of the matter is, my lord, that the TBM is designed to withstand water pressure up to a certain point, and there is no evidence, my lord, that that point was breached. Experts, my lord, say that that point cannot be breached unless and until, my lord, water travels from, my lord, a higher level to a lower level, which increases water pressure. Just a table of water will never create that water pressure. That's, my lord, called an Artesian condition, where water travels from top to bottom. This, my lord, cascade of water will create such amount of pressure that will increase the water pressure to more than, my lord, 37 bar, which, my lord, can't be withstood. There's no evidence to show. The case, my lord, is that it must have gone into a water table. Doesn't matter, even if it goes into a water table. The TBM is designed to be protected, my lord, from water.
Yes.
Now, my lord, when the TBM is going through a tunnel, if there is water, muck, etc., which goes into the TBM from behind, naturally, my lord, that part of the TBM will become heavier. My lord, this is the TBM moving. If water and everything goes in, it will become heavier, it will tilt. Now, if it tilts, there has to be ground subsidence on the top. Records show that this is all August 2019. Records show, my lord, that on this journey, the brushes started getting damaged. So there were, my lord, there was a brush change.
Where do we get it from that it started being damaged? From papers?
Correspondence. I have, my lord, noted it in my notes itself. Started getting damaged, and there was a brush change. Now, a brush change in the middle is always considered to be very risky. But there was a brush change. Then there was unusual amount of water, muck, etc. coming in. Unusual amount, which was noticed by the engineer, who's the consultant engaged by the owner. And they said, we'll change brushes again. Records show that up to 31st of August, there were no spare brushes in Kolkata. Along with the notes of argument, at the conclusion of arbitration, there is a document disclosed which shows that brushes were dispatched from Madras on the 30th of August. We didn't get a chance to deal with it. But doesn't matter, even if it is, you know, dispatched on the 30th of August, it couldn't have, you know, reached the site somewhere, you know, early 31st August in Kolkata. And there is no evidence to that effect as to when it reached the site. We had to stop for a brush change. They said that we are stopping for a brush change. Engineer also said that he is having regard to the amount of ingress which are shown on the TBM monitors. Please do that. Now, when it stopped for a brush change, which is very risky because some science will not involve, as long as the TBM doesn't stop, as long as it keeps moving forward, you know, it protects itself automatically for some reason, which is unknown to me. Now, when it stopped, within an hour, my lord, large quantities of muck, water, silt, soil came inside the TBM. As a result, there was ground settlement. As a, my lord, it tilted. Admitted position. Because of this influx, it tilted. Admitted position, it came through the tail seals. It tilted. And there's enormous destruction at Bowbazar on the top.
This was on 31st.
31st. Reason for the destruction is admitted by both sides. Effect of the discussion is A, people had to be rehabilitated, large amount of reconstruction, large amount of repair, which is, my lord, a statutory obligation of Metro under the Act, Metro Railways Construction of Works Act. And remedial action is also very expensive. First of all, work was stopped. There are large number of public interest litigations. This honorable court, my lord, stopped the work. Naturally, we had also stopped. Then, my lord, we immediately appointed some expert engineers to form a committee, and we told the honorable court that this is the committee which has been formed. The committee was headed by Dr. John Endicott. He's over 85 years old. He's a tunnel boring expert. With him were other foreign experts and Indian experts. They formed, my lord, a committee, looked at it, but you can't understand what's happening below the soil. So, my lord, it was all tentative that this may or may not have happened. After, my lord, the expert body gave a report that this should be the way forward, the honorable court said that send it to somebody else, an expert institution. So we sent it to IIT. IIT said, yes, this is the way forward. And then we proceeded on that basis. The tunnel boring machine was destroyed by pouring concrete into it. Then the top was cut. There was a box cut into the soil, and it was cut and taken out. There were 2 tunnel boring machines. The other one completed the whole thing. This was, my lord, the way it went. Now, the and important thing is, there's a gentleman by the name of, I think, Guy Bridges, who thereafter maneuvered the TBM. I'm not very sure of the name, but he was also part of it. So he thereafter maneuvered the TBM and ensured it came out. Their case was
The
that
TBM was brought out.
one was cut and brought out, the other one did the whole work. So loss of time also. Now their case was, by a letter, the contract says that if it is an unforeseeable physical condition, in that case, it's akin to force majeure, so nobody is responsible. So if it is an unforeseeable physical condition, all the loss and damage caused by the incident has to be borne by me.
So you say this is not
I said it's not unforeseen. Now, when arbitration started, my lord, we went to experts to give, because there's nothing, this all happened, which has happened under the soil. It has to be, my lord, an expert opinion. So we went to Dr. John Endicott. He gave a report. We went to IIT Madras. IIT Madras gave a report. After consulting.
No, that exercise was previously done also.
Yes.
Again,
because now what has had the difference is, in engineering, once the retrieval is done, now you have soil samples. Now you know what was the actual condition because you have gone in now. So the experts call it disturbed soil. So with the disturbed soil, we went to Shibpur, IIEST Shibpur. What during our times, what our friends used to call BE College Shibpur. IIEST Shibpur for soil analysis. We went to IIT Madras for a complete picture. And the engineer, who's my person under the contract, engineer also, gave evidence in the form of a report. So, the entire case is 2 classes of evidence, really. 3 classes. Number 1 is the manufacturing capability of the TBM is an issue. That's important. 2 is the reports of the experts, because expert opinion is admissible. And 3 is soil samples, etc. at the bottom. There's nothing else. TBM, though advanced as it is, it doesn't, have the capability or to generate reports which will, provide a solution to this sort of a problem, or this provide an answer to what has really happened. When we started arbitration, this was our case, that it is because of your breach that, the TBM was damaged. Breach of 3 categories. Number 1 is you, the contractor, failed to put in adequate greasing into the wire brushes, my lord, at the rear end of the TBM, that on the tail skin. If they are not adequately greased from the beginning, what will happen is when the TBM is moving forward, because of lack of greasing, there will be more abrasion. If there is more abrasion, my lord, the brushes will get ripped off. And prima facie proof of lack of greasing is the change which is required to the brushes, because ideal situation is no change is required. In fact, when the foreign expert took the other TBM to complete the journey, there was no brushes required to be changed. So your man who manned, there is one person in the TBM which is moving forward, who he maneuvers the TBM. So if he had done it right, in that case, the brushes would not have been ripped off, because this man who's in the TBM also pumps grease into the brushes. It's not by a mechanical process. There is a pump. There is a record as to the number of strokes of the pump. We also know how much each stroke can inject into the brushes. But there's no ideal theory. So it's done by the person who's handling the TBM. He takes it forward, he navigates it, and he also pumps in grease into the brushes.
He's above the land. I mean, from
He's
here he
in the TBM.
Oh, it's manned.
Yes, it's manned. One person mans it and takes it forward. And he keeps coming out because the tunnel is built. So he has a way of getting in and getting out. Now, prima facie proof that improper handling of TBM is brushes getting ripped off on the journey before. Secondly, we have the TBM data which shows how many strokes of the brushes happened. And we also have theoretically how much each stroke can pump grease. So quantity of grease per stroke into number of strokes
you
is
also
available.
Have the amount of grease pumped in.
Yes.
That data is also there.
That data is there. Number of strokes is there. And TBM manual shows what is the capacity of each stroke. How much of grease is pumped in. So every stroke pumps in maybe 2 grams of grease. That data is there. Plus number of strokes is there in the TBM. So we know the total amount which has been injected. And the experts all say without exception, it is not adequate.
All right.
Counter evidence on their part is primitive. They say that no, enough grease was there in the grease chamber, enough grease is pumped. How do I know enough grease is there? I dipped a stick into it and I found out. But I don't want in a section 34 for your lordship to go into that question. But that's the quality of the defense. Second is improper handling of the TBM. These are causes of, these are the breaches. One is inadequate grease being pumped, which has resulted in them getting ripped off. Number 2 is improper handling of TBM. By improper handling, I mean, it's supposed to go in this path. If it veers to the left or the right or top or bottom, and the brushes are like this cover, this the pocket clip. So the second I veer incorrectly, there's going to be extra pressure on the brushes. Ideal path will create a situation where there is no undue pressure. So by the improper handling and steering, I mean maybe a little to the left, right, top or bottom, which results in pressure being put on the brushes which are already not adequately greased, and therefore they get ripped off. Proof is brushes getting ripped off, and that shows improper handling. Third is a contractor. These are design build contracts where you give the design, you do everything. It's approved by the engineer and me, but you must have your own they call it, SOP, standard operating procedure, or your special procedure to prevent ingress if it actually happens. So what is your contingency plan? If water comes inside the TBM, how have you conceived of a situation to take it out and to save the day? So they had nothing. They just watched it happen. Not water, there might be accidents, there may be some disaster, but you must have experienced people to do this. Along with this, my lord, if your lordship looks at my statement of defense, at least 30, at least
Illegitimate expectation.
Milord,
Birthday. That's why he's asking on his birthday, should we do this matter?
His birthday?
His birthday.
Oh, happy birthday.
I'm grateful, Milord. Thank you. Milord. Now, there is other evidence also.
Yes.
For example, how are banana bolts put in, how are fasteners put in. There's 30, 40 pages of, Milord, very intricate theory of experts to show that this sort of a exercise could not, was not done properly. There's large evidence. And ultimately, IIT Madras looking at everything and clearly says this is your fault. Now we go to arbitration. Their first witness is the gentleman who was steering the TBM.
Right.
Within an hour of cross-examination, the learned tribunal says that this is a waste of time. It's a technical matter. What you say is, what you ask him is irrelevant. So you should agree. In technical matters, don't do evidence. The records are there. Do a presentation if required and finish it off. Argue the matter. So, my lord, we agree. And we say that very well, all documents should be taken on record. Number one. Number two, probative value of the documents should be decided by the tribunal. So we agree that whatever comes on records, probative value will decide on the basis of whatever evidence has come. So it now becomes my evidence. It was always, and it now becomes my evidence versus your evidence. Because they have also brought expert opinion. I have also brought expert opinion. And that is the rival evidence on the basis of which three engineers will decide this matter. Matter is argued at length. And at the end of arguments, in the notes, my lord, come this document of dispatch, which according to me is not so crucial, because even if it comes on even if it is sent on 31st, it's very clear that you didn't have it with you.
Awarded copy to award.
I think I had given a separate copy of the award also. Yes. Now, when the award comes, it is unforeseeable situation. Why? Because your expert opinion is a theory, and theories may come and go and fit into textbooks after some time. Number one. So this is, my lord, the total perversity. Number two, no discussion to reject the three issues of breach which I have told your lordship. Now there comes the two, my lord, three very shocking points. My expert opinions are biased. There is no discussion on 2000 pages of evidence. Why biased? Because I went to them privately when this started. So I will, that's what else will I do? Expert opinions are for litigation. And the last and a very shocking piece of Millard decision, the engineer is responsible. You have spent crores to hire Mycel. Mycel, Millard, is an engineering consultant company. I'm sorry. Mycel has Mr. Ken Wong, a Canadian engineer here. So when you spend so much money, and if Ken Wong and Mycel can't appreciate something happening, how do you expect others? That actually turns the contract upside down. Mycel is my representative. You are to do everything. He's to approve. That doesn't mean that your improper handling, etc., will be anticipated or appreciated by Mycel. And no evidence has been considered. When it comes to award of claims, I've disputed your claims in damages, saying that your schedule is wrong, incorrect, unproved, whatever normal defenses are there. The arbitral tribunal says you did not dispute it and proceeds to award full and unforeseen
He
physical.
did not dispute what?
The quantification and the proof. I have, and I'll show the SOD. Now, my lord, kindly take my notes of argument. Lord, I'll be very brief, my lord, and quickly show your lordship. Lord, it starts with, my lord, important dates.
Yes.
So first is August 19, water grout and soil getting past 3 rows of tail seal brushes on the tail skin of TBM, which confirms the brushes were not
Past.
Yes.
Very good.
Now I'm confused. Yes, it's
It has to get
PAST.
past.
Yes.
PAST. Yes.
Should I have written PAST?
Probably.
Yes.
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 Anyway, I
Yes,
can't-
yes, yes. Your lordship is right.
No, these are
No, I know, my lord, but
yes, yes. I want to
this
understand
was
the yes.
on the night before the last day when we started at maybe
No, our dictations regularly get typed as abandoned caution.
no, we were dictation,
abundant
and
caution.
then morning I corrected it was the matter. So, my lord, I missed also.
Abundant caution may get abandoned caution.
Abundant.
No difficulty on that. Anyway, forget that.
My lord, the legendary story is, if your lordship permits me to digress,
Yes.
very important hearing in the Birla matter. Mr. Anindya Mitra said, I want to make a note for court tomorrow. So he named it bare structure of submissions. And he dictated. And my lord, Birla family was typed by the stenographer as BIRAL family. And that almost reached court. So that's the legendary story.
But there was no concept of merger in that.
No.
Anyway, yes.
Water grout and soil gets past 3 rows of tail seal brushes.
Merger is viral, you know that. Merger, it's called. Yes.
Yes.
Anyway, so water got past.
Water got past 3 rows of brushes. And this is from the daily activity report, which is recorded in the engineer's letter,
Right.
GC's letter. He's known my lord as the general consultant. Then 28th of August, GC writes that changes required, but it's not possible because you don't have replacement brushes. Plus, in the present situation, long repair is not ideal.
GC is your man.
GC is my man, the consultant, the engineer, who's supposed to interact with the contractor on my behalf.
Right.
Then, 30th August, according to contractor, replacement brushes reach the site, stand taken for the first time in a letter dated 29 January by the contractor. No document produced in the arbitration. Contractor produced type statement along with good receipt note and invoice along with notes of argument to allege that brushes were dispatched from Madras on the said date. So when the notes came, it was too late for us. It's after everything. But even if I take this, 30th it leaves. So what by 30th, most of the damage has been done and you are not in a position. 31st August, 5 p.m., TBM stopped for preparatory work for replacement of brushes. There is nothing to show that at this point of time brushes were there. Within half an hour inflow, 5:30, and then the incident of the evening. Now, case of the petitioner, which I indicated. This is, my lord, improper and lack of greasing. And second last line of the paragraph, 73% of reduced volume of grease was being pumped. And there is, my lord, 15 to 20 pages of evidence by the engineer in his evidence, in his report, which was one of my 3 crucial pieces of evidence with charts to show this, based on, my lord, the TBM data and, my lord, the grease data and the mathematical calculations.
This was your expert's report, your engineer's report.
My engineer's report.
Was it corroborated by IIT or the others?
Yes, my lord, I'll just show IIT's report.
Yes.
That's, my lord, totally independent. And the more fundamental question is that why do we go to engineers for the purpose of a decision making of this nature? So that, my lord, the tribunal is also, my lord, comprised of experts. They understand it more.
Appointment by you may not vitiate it, but if it's your employee, then tribunal may have a point there. Yes, but IIT is not your employee, neither is that Shibpur.
Neither is Shibpur. Now, what I was trying to, my lord, get to is that I go to, my lord, a technical tribunal for the purpose of better appreciation of technical matters. That's the logic. But this technical tribunal doesn't decide any matter. It rejects the whole evidence and a whole arbitration done over a year with foreign experts coming in to give presentation and give reports at expenditure of crores of rupees and nothing decided. I'll show the award. So this is number 1, and, my lord, I've given the pages. Even the engineer's report, my lord, says this. The data sheet, etc. is here. Then second is improper handling or steering of TBM, and then failure to stem inflow of water into the TBM. The 3 causes I mentioned. Now C is case of the respondent. A, unforeseeable physical condition has resulted in the incident. I'm on the top of page 4, my lord. B, GC has not instructed or advised in a manner that would prevent the incident. This is totally contrary to the contract, which, my lord, in no uncertain word says breach on your part. GC is not responsible. You are responsible. Contract says so.
Particular clause.
Yes, I'll show the clause.
Just give the clause so that I can take a note here beside this point. You can go on, carry on, and I'll just take a note of the clauses beside this point.
I'll tell you where it is. No, I'll just.
Yes. To just take a note of the clause.
While I'm here, I'll volume 77.
Volume 77?
Yes. There is 120 volumes or something. The evidence was thousands of pages of data.
Not your fault.
Drawings, etc.
Chaudhary, in the meantime, Mr. Basu, please just indicate some of the salient clauses. Just indicate on a piece of paper. I can take a note on
this page which I am asking Mr. Basu to take out. Yes, has a schedule of all the contract clauses.
Give the page number and the volume. Volume is volume is
It's
77
12272.
Page.
12,270.
page.
Yes, my lord. I'll just check once, my lord. Volume 77 is wrong. My lord,
78 should be.
I'll just check whether the page number is
78 is
also
up to 12250. So you
Yes.
say 72.
wrong. Brief আছে না? আর কর না।
The Chaudhary will take
No,
it
I am
later.
making a mistake, my lord. I'm sorry.
Did not. We'll do that later. Let us just follow your arguments first, the nutshell.
Very well. একটা আমার নোটসটা কোথায় আছে? Before the arbitral tribunal. Lord, I'll come back
Yes,
and
yes,
show
come
the
back, come
clause, my lord.
Later on.
My lord, so Lord, contractor would be responsible for the damage and would indemnify the employer. Contractor would cause survey and would be deemed to be aware of all site conditions and factors.
You're reading from?
Not my note,
No,
page 9 of my note. The
Yes.
three.
Yes.
Oh, I'm sorry, my lord. I have just jumped 4 pages for no good reason. I was at page 4.
Yes, page
I was at page 4. So his argument was that unforeseeable physical condition had resulted in the incident of ground settlement. To GC, yes. May I digress again once, Millard?
Volume?
That this is volume 73, page 11533. এবার ক্লজটা বার কর। You have seen this, Millard?
Yes, yes.
This is my notes of argument, which runs into, which is quite
So,
exhaustive.
written notes of argument on behalf of the respondent, why does it say?
Millard, I was the respondent in the arbitration.
But this was the
Millard, what had happened was, I said that this is all on your account, and I'm going to deduct from your bills.
oh, achha, they
So
challenged that.
they challenged that and they came with the claims. So I am the respondent. Now, Millard, this has, for no other reason, I'll come back to this later to show what I had argued. But Millard, please come to page 11548. The last clause, Millard. The contractor shall be responsible for the safety, security of excavation at all times during execution of the contract. The contractor shall present to the engineer details of everything. No excavation shall take place until the employer representative consent. Then, Millard, he has to, contractor shall at his own expense conduct soil investigation, design, etc. to identify that it's prudent to do whatever he has to do. So, Millard, he's done so. There is something called a GIR, which is not geo something report. Millard, the GIR is his soil report. Then excavate, next page, Millard, excavation with care. Then page 11552. Contractor deemed to have inspected and examined the site. Risk of injury and damage is all his. Then 4.23 is important. This is his case. If during the execution of the works, the contractor shall encounter physical conditions which, in his opinion, could not have been reasonably foreseen, contractor shall give written notice. And if in the opinion of the engineer such conditions could not have been reasonably foreseen, engineer shall certify, etc. The other contract clauses, 11556, risk and liability of the contractor. He has to take full responsibility for the site. Then any damage is
There are several clauses.
several, my lord.
Very. So let us continue with your written notes.
Yes, but what your lordship had asked me to show, my lord, I have been unable to.
No, all these clauses cover that point.
No, there's a direct clause, my lord. There's a direct clause. I'm very sorry, my lord. I should be prepared to show it. সেটা কোথায় আমার না দেখা যায়? Millard, I'll just read it out. Contract is, Millard, also filed. It's 3.4 of GCC. No act or omission by the engineer or the assistants to the engineer in the performance of any of the engineer's duties or the exercise of any of the engineer's powers under the contract shall in any way operate to relieve the contractor of any of the duties, responsibilities, obligations, or liabilities imposed upon the contractor by any of the provisions of the contract. Now, may I hand this up? This is on record.
I read it out. It's all right. For the timing, it's okay.
Oh, yes. I'm grateful to my learned friend. This is page 11541.
Thank you.
Look, these are, Millard, PDIC contracts. Standard form of, Millard, FIDIC is unpronounceable. It's a French name, which is copied all over, even copied in all our government contracts. And, Millard, they are designed in the way that contractor gives the method approved by engineer who's hired by the employer to, Millard, approve the method. Here the method would be tunneling, TBM, etc., etc. And TBM is chosen by him, approved by the engineer. Secondly, all risk is always of the contractor. Some data is provided. Here also there is a DPR done by the Delhi Metro, which is given to him. There's a soil test report given to him. And there's a clause that you have to independently do your reports. So you can't ever come and say that I didn't know this was there. That's number 2. Number 3, engineer approves and deals with you on behalf of the owner. It does nothing else. A contractor's risk of doing improper work can never be passed on to the engineer. That is how the contract is made. Otherwise, your lordship will see what will happen. Whenever there is something wrong or a breach, he'll always say, you're the engineer. Why did you let me do this? That doesn't work. The contract is clear. And in these matters, Millard, contract has supremacy over everything else. Now, Millard, to support its stand, so this B, Millard, is absolutely out of, Millard, contrary to the contract. To support its stand, the respondent relied upon the following report. Number 1, report of Mr. Charles Mann. 2, Geoconsult India Private Limited. 3, Subarna Jurong Consultant Private Limited. And 4, Herenchnet India Private Limited. These reports in the course of arguments, and I'll show that portion from my notes, we have distinguished on, Millard, some principal grounds. Number 1, like for example, Millard, Herenchnet. Herenchnet is the TBM manufacturer. It's nobody's case that the TBM was inappropriate. In fact, it's my case that the TBM is perfect. So what can the manufacturer say? Manufacturer says that yes, it was perfect. That's all. And I presume that there has been more water pressure. But where is your evidence? The other
In
report,
the written notes by respondent, you mean them?
you, by me in the arbitration.
So this was your report. These were your reports.
No, this is for your lordship's court. So this is his. So his reports are prima facie, or why should I say prima facie, are inadmissible and irrelevant because of three principal grounds. Number one, these are pre-retrieval reports. Most of them are pre-retrieval reports, which are reports in the blind.
Your reports were also pre-retrieval.
No, all the main reports which I relied upon are all post-retrieval. I didn't rely on pre-retrieval reports because all my pre-retrieval reports say, including Dr. John Endicott's report, say that pre-retrieval, it's only assumption and the actual cause will be unearthed upon post-retrieval. So his reports, my lord, are pre-retrieval reports mostly. Secondly, his reports don't give a theory based on facts as to why this happened.
It's like an exit poll sort of.
Yes.
So
for example,
it may be trumped by the actual poll report.
Yes. So that's for pre-retrieval reports.
Yes.
That is pre-retrieval. Second is, what is shocking is his reports, one say that Kolkata is sitting on water. And how do I know? I know because I found a newspaper article saying so. That's why Creek Row is called Creek Row, because it's on a creek. Newspaper reports and some experts, my lord, some journalists looked at for Kolkata conditions and they say, okay, this is the reason. I'll show the reports. Now, this is not considered. These reports are found to be perfect, but my reports are found to be partisan and biased.
Yes.
And ultimately, my lord, claims awarded in the blind without considering my objection. Now, my lord, see what I have to say about the reports, my lord, page 4D. The principal evidence in this arbitration is by the reports of the experts in the field and engineer GC. The following facts are relevant. When the incident occurred, an expert committee was formed comprising of Dr. Endicott, Dr. Guy Bridges, Dr. Pichumani, and Mr. Shuman Dotto. The said committee submitted a report on 13th November. This is a report prior to retrieval. Petitioner has relied on this report. In the course of arbitration, along with disclosures, petitioner has relied upon the following three reports. Report of IIT Madras, post-retrieval. Report of IAEST Shipur, post-retrieval. Report of engineer, which is my evidence really, post-retrieval. All these are post-retrieval. Contractor relies upon 4 pre-retrieval reports of TBM. Report of Mr. Charles Mann, without relying on any evidence, states that there is possibility of an aquifer, though nothing in the report supports such view. Watertight TBM is designed to encounter an aquifer, so this is not a problem. Report also records that there is artesian condition while relying on the soil investigation report of February 2017, which itself says that no artesian condition was encountered in any borehole. So, my lord, this report says that there is artesian condition. My lord, if there is artesian condition, my lord, is water traveling from up to down or down to up with pressure. It can, my lord, as far as I remember from my interaction with the experts, I'm not very certain, 2-3 years have passed. It cannot be from top, my lord, bottom to top. It's usually from top to bottom. And there is, my lord, a measurement of pressure, which is called bar. So, my lord, there is no evidence, my lord, that there is any artesian condition which increases the water pressure to an extent which, my lord, the tunnel boring machine cannot withstand. This report says there is an artesian condition. relying upon the GIR, which is the soil investigating report at the commencement of the contract based on, my lord, borehole logs. Now, this report itself shows that there is no artesian condition. So this, my lord, report of Mr. Charles Mann is perhaps not of any consequence.
Newspaper articles also.
Yes. Then report of Herenschnett, the manufacturer of TBM, proceeds on the basis that TBM was designed, but without any support or basis that the probable cause of the incident is unforeseen adverse geological condition or unexpected high water pressure. This is pre-retrieval based on surmise. Manufacturer says, possibly there is something like this. That he may do so. He says possibly, I can't blame him. It is a possibility, but that you can't use in arbitration to get an award, which, my lord, has a cascading effect of 500 crores. Then, Geoconsult India Private Limited, Dr. Florian Kren, on assumption recorded on the basis of soil condition that loose sand below the silt triggered a settlement. However, this is again assumption, since the soil samples from the tunnel post-retrieval were not analyzed or taken into consideration by the said soil expert. This report proceeds on the basis of an article. This is, my lord, shred to pieces by IIEST Shibpur, which had the disturbed soil samples. And IIT Madras, when the issue was referred to them, they on their own, while giving a report, because soil dynamics was so important, they referred themselves to another expert on soil dynamics whose views were taken by them, which I will show. Then report of Subarna Jurong clearly mentions that the actual cause may only be verified upon recovery of TBM and the exact cause is unknown, pre-retrieval. So this evidence is zero evidence. Then award, my lord. This I have said, formal proof dispense with, etc. Now, my lord, I'll show your lordship 10 pages of the award, out of which 9 pages I had shown previously. I'll quickly skip through them and come and read the last page. In fact, my lord, let me read the portion which I had not read on the earlier day and then go back to the earlier portion. Because this, my lord, was the most shocking portion. It was with great regret, my lord, that my time was up. I couldn't read this paragraph. My lord, assessment of the arbitral tribunal starts from page 77 of the award. And at page 90 is the end of the reasons. My lord, 77 to 90, 13 and a half pages decide my fate. The culmination,
What is that?
is at page 122. I'm sorry, my lord, 121. The arbitral tribunal considers this to be so important that it's put in bold. I had stopped, I think, at page 1, paragraph 116. I'll read 121 and then read the rest. Lord, please see this. A lot of theories.
Which page?
This is below 89, paragraph 121.
Yes.
Lord, I'm using the internal page numbers in the award.
Yes, yes.
A lot of theories and opinions will keep on emerging as we go deeper and deeper into the micro issues of causes of failure, and would be a matter of several technical papers in the journals in the future. And after research, some of the conditions which lead to the accident may become clearer and clearer with the passing of each day. We are here to judge the issues from the engineering point of view. Engineering is not a pure science, but an applied science with lot of design constants and coefficients derived based on past experience. It is possible that after the present incident also, some of the coefficients and constants could stand modified, like the additional modifications carried out while carrying out the work after the incident. However, these are just preponderance of probabilities with improvements to cover any further unforeseeable physical condition. Engineering evolves constantly by having a healthy mix of theory and ground experience, and that is how empirical formula and future guidelines or codes get upgraded. These improvements have no end, and no one can be sure if these improvements could have contributed to the safe passage of TBM2, which is the other TBM, finishing the work, or were just superfluous additional safeguards. None of these theories can put a definite blame on the claimant's conduct on the date of accident. Thus, unforeseeable physical conditions in terms of clause 4.23 of GCC on the day of the incident appears to be the plausible assessment to the entire incident. The case of the claimant is allowed. No, this is uncalled for. Now, last time I forgot, and I'll come back to it. Mr. Basu just prompted me. Contract has clauses which say no damages, accepted matter, etc., which were all disclosed to the tribunal. The tribunal there's not a page of discussion on that. That's the first thing which had to be discussed. I'll come to that later. But first, my lord, ethically, what has to be done with a case of this? My lord, please see now, my lord, page 112. From 111, my lord, paragraph 111 at page 77. This is where, my lord, assessment of the arbitral tribunal.
Yes.
From the above report, certain issues as follows is the assessment in order to assess the issues raised by the parties. A. Assessment of the causes of failure. B. Assessment of GC's roles and responsibilities as engineer for the project. Assessment of GC's role as engineer for the project. Paragraph 112. Referring to clause 3.4 of GCC, respondent argued that no act or omission by the engineer or the assistant to the engineer in the performance such and such will relieve the contractor. This is the clause I showed your lordship. Now, my lord, 4.1 on the next page. Respondent contended contractor shall take full responsibility for the adequacy, stability of site operations. First provision under clause 3.4 makes it mandatory for the contractor to comply with instructions given by the engineer in accordance with the contract. Hence, fundamental point to consider is whether or not claimant has defied GC's instructions, and if so, whether GC had objected to such defiance. If the answer is in the negative, then GC cannot avoid its responsibilities for all consequences arising from such instructions of GC. There is no evidence of non-compliance to any directive or instruction of GC by the claimant. Now, my lord, I'll stop here for a moment. You are doing tunneling. The whole SOP is by you. It's approved by GC based on your GIR. What has GC got to do with it? And please look at the contract. Contractually, GC is not responsible. You are responsible. But otherwise, and yes, I would have understood, my lord. I would have understood. Even it would have perhaps been arguable if there was evidence to show that they wanted to do tunneling in a particular way, and I did tunneling in a, I'm sorry, they wanted to do tunneling in a particular way, or they wanted to change brushes, or they wanted to put more grease, etc. And the engineer says, no, don't do it this way.
Apparently, in para C, the tribunal inverts clause 3.4 on its head.
Yes.
Because see, the observation of the tribunal is 3.4 makes it mandatory for the contractor to comply with instructions given by the engineer in accordance with the contract. Please come back to A and read it out once.
Yes.
3.4. Say that the contractor is bound by the instructions of the engineer. Let us 3.4 has been
Yes.
referred. Please just read it out once again.
The respondent argued that no act or omission by the engineer or the assistants to the engineer in the performance of any of the engineer's duty or the exercise of any of the engineer's powers under the contract shall in any way operate to relieve the contractor of any of the duties, responsibilities, obligations, or liabilities imposed by the contractor under any of the provisions of the contract.
So at least clause 3.4 does not say that the contractor has to follow the injunction.
No, it does, my lord. That's a separate portion. My lord, 3.4 says contractor shall comply with instructions given by the engineer in accordance with the contract. But what are these instructions? My lord, one has to see, my lord. Can now kindly take,
And
my
this
lord,
is the second portion which you have relied on.
Yes.
That this will not absolve
Yes.
them of the liability.
Yes.
All right.
Contract volume ta dekho. Volume of the contract. আলাদা করে file করেছে তো? My lord, may I just show the contract volume? This portion is very important. Is in that page number which I had indicated. No, I want to show the contract, not the excerpt. No, I'll just tell you a lot.
This is the excerpt.
Because I need to show the whole clause.
Yes.
12272. Take out 12272. This which is volume 77, which had been taken out by. Let me check first before I trouble my
volume
lord's officer.
78. 78.
পরের ভলিউমটা volume 78. দেওয়া আছে
না আলাদা করে জাস্ট এটাকে পুরো
ইন্ডেক্সটা দেখো না 130টা ভলিউমের I'm sorry, Milord, we should be more.
This is not the agreement. 12272.
Milord, this 122. That's my contract with the GC.
Oh,
Which, Milord, I was compelled to produce.
no, but this is not that contract.
No.
it's not a
It should be in some earlier volume, I suppose. I mean,
এরকম দেখতে
that is more important.
ওরম দেখতে কিছু আলাদা করে
আলাদা করে ফাইল হয়েছে
Oh, the contract has been separately filed.
apart from the compilation.
Contract is not a part of the paper book.
No.
ওই
Even in the arbitration, it was
spiral binding দেখতে পারি।
spiral.
Copy then Mr. Chaudhary lose.
No, it's not golden. না golden নাই, but ওটাই।
এটা দেখে এক সেকেন্ড দিন। আচ্ছা, কন্ট্রাক্ট এগ্রিমেন্ট পার্ট 2 বার করে দিন।
রাখবেন কোথায়?
কন্ট্রাক্ট এগ্রিমেন্ট পার্ট 2, পার্ট 1, পার্ট 2। হ্যাঁ, পরেরটা মোড়াটা। হ্যাঁ,
শিওর তো?
হ্যাঁ, 200%।
এটা সোজা করে দিন, ফ্ল্যাট করুন। Volumes of contract.
Yes. Now, my lord, please, there's a type.
Volumes কোথায়? এইগুলো?
এইগুলো
এগুলো দিয়ে দিন এখানে, কোনটা লাগবে কখন আপাতত থাকে এখানে। Yes. There are several parts, 6 parts probably.
Yes. So, Milord, this is the contract agreement 2, part 2. This contains the general and the special conditions of contract. This is the most important, Milord, part.
This is volume part
2.
Part 2, right?
It says, Milord, contract UG 2. Then it's on the top, Milord, in a box, it says part contract agreement part 2.
Part 2, right?
This, Milord, if your lordship sees the first page, it has, Milord, a index, general conditions of contract, special conditions of contract, including schedules.
So we are now looking at the GCC.
Yes.
General condition.
I'm showing, Milord, the GCC. Now, if your lordship sees page 914, it's in, Milord, a rubber stamp at the bottom, or GCC 14.
GCC
Milord,
14, yes. 3.4 is at GCC 15.
3.4 is at GCC 15.
Yes.
But Milord, please come to the earlier page.
Yes.
The engineer. This is not the engineer's role. The employer shall notify the contractor in writing of the appointment and identify of the engineer of any replacement from time to time. Engineer shall carry out the duties specified in the contract. Engineer shall have no authority to amend the contract, may exercise the authority specified in or to be implied from the contract. If the engineer is required to obtain specific approval of the employer, he shall do so. Then engineer cannot relieve contractor of duties. Then representative. Now, Milord, 3.4. Contractor shall with instructions given by the engineer in accordance with the contract. 2. Contractor shall give reasonable notice to the engineer of instructions. Then no act or omission by the engineer or the assistants shall relieve the contractor of any of the duties, responsibilities, obligations, and liabilities.
So taken together, the contractor shall comply with instructions, but no act, not only omission but act also. Act of the engineer or assistants operates to relieve the contractor of any of his duties. Act includes directions.
Yes.
If it is the contractor's duty otherwise.
And what is a contract? If your lordship looks at the contract, the method, Milord, is given by the contractor. It's approved by the engineer. Here there is no problem with the method. It's not my case that the method is wrong. But I would have understood even a, Milord, semblance of an argument contrary to the contract based on, Milord, equity could have been made if they had been able to show that you, the engineer, asked me to do this because I did this, this happened. That's not the case. What is the case? The case is you did not see it happen. You are an expert. So how can I be held liable? That's absolutely incorrect. Now, Milord, if I may go ahead to go back to the award. Respondent, the fundamental point to consider whether the claimant had defied GCC's instructions, and if so, whether GCC had objected to such defiance. But where is the first question? Has the GCC directed you to do something which has caused this? And is it something beyond the scope of the contract? If the that question is not asked, onus and burden of proof, Milord, turns on its head. Then, Milord, paragraph D. Respondent further contended that an unforeseeable condition should not be foreseeable to anybody. That's our argument, Milord. In fact, this is also case of the claimant. If it is foreseeable to anyone, it is, and it should be foreseeable to all, including GCC. So, my lord, including GC. So, GC did not foresee it. So, why make the contractor liable? So, you are acting in breach and GC should foresee the effect. The respondent's second argument is that even if it is foreseeable, the same should not come under the purview of clause 4.3 dealing with unforeseeable physical condition. Role of GC has been listed, which includes. Now, this is not very interesting. GC will carry out construction, erection, supervision at various levels. Well, that's good. Doesn't will not disturb my argument. 2. In its letter dated 14th February 2020, respondent instructed to recommence tunneling work after the incident. The last paragraph of the letter stipulates as follows. GCC is requested to ensure adherence to the recommendation of expert committee as well as IIT report religiously on 24/7 basis. Already established protocols for supervision by GC not to allow any ad hoc measures. Now, this is after the incident when recommencement of the work happened. An instruction was given to the GC that you ensure that IIT's report is followed so that it doesn't happen again. And that is now taken to be the GC's role. And that is taken to be to absolve the contractor of all obligations. Then obvious question therefore is what are GC's obligations as per the contract between the respondent and GC, which were prevailing prior to the incident. Emphasis already established protocol for supervision by GC. In order to search for the answer to this very vital question, the respondent was directed by arbitral tribunal to provide a copy of the agreement between the respondent and GC. A copy of the agreement, GC part, was filed. Upon perusal of the said GCC, it is evident that the role of the GC has been expressly provided in clause 7 at page 16 of the agreement between the respondent and the GC. The terms of reference from GC have been further stipulated that these are the obligations relating to performance guarantee has been deleted. Accountability of GC has been removed. So now, you look at my contract with GC, look at certain clauses and say that why has GC's accountability been released, been removed? Clauses inserted in the contract between respondent and GC creates an irreversible obligation upon GC to carry out construction or erection supervision at various levels. So that's fine. That's his job. He's a supervisor. And the contract also says that that doesn't absolve the contractor of all liability. So, my lord, if one follows this theory or this interpretation, in that case, a contractor will never be liable. In all these cases, there is an engineer. Always engineer will be liable. Lord, I can understand with the most charitable thought towards this argument, I can understand that if somebody ever comes, and I checked up, my lord, authorities also, that if one comes with a definite case that the GC's instructions have caused this mishap, which were contrary to what the contractor wanted to do, one can understand even a walk on this path. But here there is nothing.
Does the award anywhere discuss about those aspects which are highlighted by you, like the brushes that were not greased
Yes,
properly?
my lord, I'll show now.
Because that is the important thing which has to be looked.
Yes, my lord.
These are shifting of liabilities.
Yes. Now, next page, my lord, 113.
Yes.
Cause of incident. My lord, I'm sorry, I'll just next page, my lord, lordship will see this is GC. So now he made no judge of his own cause, bias, and apprehension. My lord, please see J, my lord. This is
Yes.
not appreciating. My lord, I'll just read this, my lord.
So report of GC is sought to be.
More than that.
Huh.
G, my lord, instead of intent of respondent to appear from the expert committee was constituted by the respondent with the engineers of constituents of GC for the purpose of providing a report for recommencing the tunneling, reviewed by IIT. More importantly, respondent entrusted GC to furnish a final report, and same was accepted by the respondent. Even in the final report, GC could not justify its clean and diligent role. Why? No reasons. It's a 100-page report with full data and one sentence. In any event, report of GC, apart from various other technical infirmities, what are these infirmities? Suffers from the vice of the settled principle of law. No man ought to be a judge in his own cause. No one can be suitor and judge. Ostensibly, such report is tainted with bias and apprehension. Without using this logic, no evidence can be given by a party. Also, no effort appears to be taken by respondent to ascertain as to whether there was role of GC in the matter of the incident, which is a predetermined stand to pin offense against the claimant only to unconscionably and unlawfully avoid payment of sums payable. Then, cause of the incident could be contractor's failure to adhere to GC's instructions, B, failure of GC to ensure compliance of all requirements, none of the above. But please note, could be. Claimant has to prove his case. There is no evidence to this effect. And, Milord, I'll show the statement of claim. Milord, it becomes very important at this stage prior to moving to 114. Milord, what is the case against GC in the statement of claim? Please see this. This is shocking. Milord, page 344 of the petition.
Petition. 344, third one.
Milord, it starts with, this is the statement of claim. Milord, first is introduction. Let me omit all of that. Then, Milord, there was a realignment. Page 357, Milord, is realignment. Where, Milord, the plan was changed. Let's again, Milord, omit all that. Then, page 365 is where it starts. Incident of ground settlement. This is what happened. And then, Milord, how the matter proceeded. Then, page 370 is causative analysis of the incident of ground settlement. The 4 reports dealt with. And page 375 is, Milord, paragraph 6.7 is his case. Following inferences emerged from the facts, expert reports prove the cause of incident of ground settlement was due to unforeseeable geological condition, unexpected high water pressure, or something not known.
Was any blame cast on the GC that in the...
No. C is, Milord, on GC is only TBM was approved by GC. Yes, it was, and there's no problem with the TBM.
Not, yes.
And then 1, 2 is, Milord, tried to be proved on those 4 expert reports, and that's it.
So they cast the blame on the conditions, the unforeseeable geological condition. Basically.
Yes.
Not the GC's.
No. Milord, only thing is, Milord, please see this, Milord.
Attributability of ground settlement.
Yes. And in the rejoinder, yes, this was his case.
No, page 377, Mr. Chaudhary.
377.
7.1. 7.0 is on attributability of ground settlement incident.
Yes.
And they say,
And
as
he's-
has been pleaded elsewhere, the claimant has been following all instructions and advice of the GC. But that's general, not
It's a
that
general
this
thing.
incident
You
was that-
have
that-
to. You have to. Now oh, I'm sorry, Miller.
Well, I'll come back in.
Yes, Miller. Not, with your Lordship's permission, may I ask one of the senior officers of KMRCL to sit here, my Lord, if you'd
Oh, yeah, absolutely.
My Lord, kindly take the contract one. This is something I wanted to show, and I'll come back to the statement of claim in a minute, my Lord. Just two clauses. I had shown your Lordship, my Lord, GCC 14, engineer. GCC 14, engineer. Which is page number is GCC 14. There's
GCC
also
14, I'm sorry. Yes.
Lord, on your Lordship's copy, my Lord, there's a that rubber stamp page number, I think 00014.
Yes.
And then, my Lord, if your Lordship follows this I placed. If your Lordship follows, my Lord, the rubber stamp page number 00078. This is, my Lord, special conditions of contract. Which is in addition to GCC. Clause 2, functions of engineer. In addition to the duties mentioned in clause 3.2 of general conditions of contract.
0078.
00078.
Yes, got it. Functions of it.
In addition to the duties mentioned in clause 3.2 of GCC, to the duties shall watch and inspect work, monitor test result, examine material to be used, shall carry out such duties and exercise such powers vested in the engineer with the contract, shall issue instruction, etc. Opinion desirable. This doesn't mean he is responsible for whatever happens.
The issue is with the operation of the TBM. So there is nothing to show that engineer had any function in that or role in that.
Yes, nothing shown. Now, my Lord, statement of claim 37. I'm sorry, my Lord, page 377, clause 7, attributability of ground settlement. Last sentence. Last three lines, as have been pleaded elsewhere in the statement of claim, claimant has been following all instructions and advice of GC in carrying out both tunneling work and other ancillary work without any deviation. So, my Lord, up to this point, statement of claim is case was, this is unforeseen. Look, I've been doing what GC has been telling me. If I didn't foresee it happen. And this has happened because of XYZ for which I am showing reports. This could have happened for XYZ, I am showing reports. Now, my Lord, in the rejoinder, after my statement of defense comes with all this evidence and all the reports for the first time, in the rejoinder, a case is sought to be made out. This is volume 44. Which we've taken the liberty of a shift in stance, my Lord. That why are you blaming me? Blame the GC. My Lord, rejoinder starts from 7265.
Yes.
At 7269, towards the middle,
yes,
the said chapter suggests the two-tier organization was to be set up. At the apex will be KMRC itself, and second level will be a project management team called general consultant who would be engaged by KMRC and will fully be responsible for planning, design, and full project management as the engineer. Then, page 7275. I followed engineer's instructions. 7275 bottom. I'm not reading the page, but I followed instructions of engineer. And 7276 is the pleading. Hence, obligations of the claimant cannot be considered in isolation without considering the fundamental obligations of the respondent and engineer for carrying out contractual work. It is therefore denied and disputed the claimant was or is alone responsible. This is rejoinder. Now, my lord, let's see, my lord, what is the answer to the main issue. (114). The GC could not establish that the claimant had defined to such defiance by the claimant. As has been mentioned, no step was taken by the respondent to end.
Where are you reading?
The award.
Yes.
Page 80 of the award.
Yes, please carry on.
The cause of the incident is probably contractor's failure to adhere to GC's instructions. No such case is made out. Then failure of GC to ensure compliance. No such case is made out. None of the above. Now, my lord, please see. GC could not establish that the claimant had defied GC's instructions. GC is not a party, and there is nobody's case. More so, there is no instance or evidence that GC had objected. Then active involvement negated independence of the committee. Then, in addition, few indicators of bias are reflected in the following incidences. Issue of non-availability of stock of tail seal brushes. Here, it says claimant placed orders on such and such. About 100 number of brushes were delivered by HK 30th August 19. This is with the notes. And therefore, thus as on 31st August, brushes were available. No evidence. Zero evidence. 30th you dispatch. Let's accept what is given with the notes. 30th you dispatch. How do you know 31st is there? Second is, why was it not there before 31st? Then regarding VMT report. Submission were made by the respondent that there was no proof that the TBM had sunk by 1.5 meter. A VMT report.
What is VMT?
Generates along with the running
Oh, it's a TBM running generation report. That's called a VMT report. VMT report was filed before the arbitral tribunal, raising an allegation of suppression by the claimant. Further alleging that VMT report does not indicate any settlement. On the first point, claimants such and such, I'll omit. Then again, suppression. Now, way forward scheme for balance tunneling. This is IIT Madras to High Court. That's a separate IIT Madras report, which High Court saw and allowed retunneling. Then there was an allegation by the respondent. So therefore, these are indicators of bias. Now, please come to Milord, page 84. This is findings on initial and final report on IIT Madras. Arbitral tribunal's finding. Report initial report before completion. Initial report before completion of removal process and final report. Under the heads of terms of reference of the letter, the inputs required for carrying out will be provided by KMRCL. But as per claimant, neither he aware of such appointment of IIT Madras nor any opportunity was given to provide inputs. Respondent has not given any evidence to this effect. Now, what is crucial is initial report was taken for the purpose of submission in the public interest litigation. Why should the claimant be consulted at that point of time? Court wants a report. And in any case, the initial report is not so relevant. The final report for the arbitration, which is important. Final report relied on removal of tailskin brush seal report prepared by Lee Blade. It is interesting to note that the tailskin brush removal was completed on 28th January. So how the report can be prepared early before complete inspection? So inspection wasn't completed, but the tailskin brushes had come out. I'm sorry, that full retrieval had not been completed, but tailskin brushes came out. Then IIT Madras also could not verify the inspection report, and they have stated that the quality of photographic evidence cannot guarantee accuracy of the comments made by Lee Blade, which is contradicting with the last point of attributable factor that tail seal was extensively damaged. So now I must show this. Milord, it's a small report. Milord, please take volume 43.
Yes.
This is the report of my evidence, brought expert evidence of IIT Madras. Second paragraph, I'm sorry, fourth paragraph. The report was prepared by a team of faculty members from IIT Madras with help of Dr. G.J. Page, an expert in tunneling and TBM operations from G.J. Page Limited, Hong Kong. Based on the data supplied and all the photographs from the daily progress report of TBM, it is clear that water egress is caused due to operational reasons as highlighted in the report. We sincerely hope that the report will help KMRCL, etc. Now, Milord, please look at 7087. Introduction. I'm not going to place the report, but I want your lordship to see the exercise carried out by the experts. 7, scope of work, Milord, is mentioned. Then page 7089, likely reasons of the incident. And look at, Milord, the detailed analysis. And Milord, 7091, the diagram. And this is, Milord, the borehole log being considered to see, Milord, the nature of the soil. Then investigation of TBM related aspects. Then, Milord, this is, Milord, 7, Milord, this detailed, Milord, analysis. Detailed analysis goes on. Now, kindly look at, Milord. I'll just take it, Milord, because of it's not possible to read the report. But please, Milord, come to the conclusion of the report. At, Milord, 7129. Discussions and conclusion at 7129.
Yes.
At the bottom, the potential tail seal failure is down to puncture, high external pressure due to external pressure, groundwater. B, brush failure due to low grease pressure, etc. Brush seal deformation, etc., etc. Incident cannot be attributed just to a failure of the tail seal, but also to inadequate planning, risk management, quality control, supervision, general management of tunneling operation. When the first maintenance of the tail seal was carried out, why was no investigation done? Then, when the tail seal was maintained again, it goes on. Then overall assessment, the detailed examination of the soil profiles from the various boreholes showed the subsoil consists of layers of stiff clay, such and such. And then on the next page, soil profile is also more or less uniform along the tunnel alignment. Consultants conclude that geotechnical conditions at Bobazar incident are no different from those at different locations in the metro construction area. Based on examination of soil data, the undersigned consultants opine that the tunnel water incident is not caused by any exceptional geological conditions at the site. On the other hand, examination of the TBM operational procedure adopted for the project shows notable shortcomings in the management of TBM operations, along with failure of tail seal. As described above, the tail seal was damaged, either being ripped off when the tunnel segmental lining became skin bound against the tail seal, or when grout infiltrated the outer brush seal due to high grouting pressure and low grease pressure, insufficient grease. From the photographic evidence at the time of tail seal removal, it can be seen that a large percentage of the spring plates and tail seal brushes are damaged or missing. There is lack of grease amongst the brushes and chambers, and much of the brushes and chambers are contaminated with grout. This would have led to ingress of water and fine soil particles. Now, this, my lord, is completely, my lord, shot down because of one earlier sentence that quality of photographic evidence cannot guarantee accuracy of the comments of Lee Blade. And now, my lord, kindly look at the most important part. Initial report of IIT Madras was before retrieval. Initial report, forget about initial report. Final report cannot be, my lord, AF, paragraph 1, AF, Act, page 85. Final report cannot be an impartial or independent assessment. Claimant's reports were given to IITM, which was not given initially, to prepare the defense mechanism on behalf of the respondent. Claimant submitted report on such and such, and this would have been considered by IITM in their initial report. So, because I gave his 4 reports to IIT Madras to take into consideration, or I could have done so, his report is not impartial or independent. But what about his opinion? And then look at this, my lord. Next, AG. At page 986, IITM reports rely upon SPT values to state the higher SPT values indicate that soil is strong. However, since all the 3 arbitrators are civil engineer with more than 40 years of experience, and one of them being a postgraduate in geotechnical engineering from IIT Delhi, the professional knowledge makes them differ with the report of as SPT values can be misleading, etc., etc. Then B, paragraph B, there is no contrary evidence to the statement of the claimant that sink of TBM is not due to fault of brush. This whole report is that. Now please see the next paragraph. Then they go back to, my lord, the first report of Dr. Endicott, and that was probable because no retrieval. So that is, my lord, noted. And then, my lord, I'm omitting. Last time I read this, so I'm omitting. Paragraph 116, my lord. To at page 88. That 80 had observed, 116, my lord, that 80 had observed that while immediately after the accident, claimant had made extensive efforts to analyze the cause of incident and engaged independent and globally renowned experts in the field of tunnel operation. On the other hand, initially till submission of pleading in defense, the respondent or GC never pointed out any mistake on the part of the claimant. However, immediately after the statement of claim was submitted, the respondent commissioned a series of studies with the sole purpose of preparing the defense against the issues raised by the claimant. Hence, the conduct of the respondent raises serious doubts on intentions and objectivity in putting up the truth.
Yes.
Importantly, the respondent did not lose faith in the capability of the claimant, etc. Because they've continued. And then comes this conclusion. Now, my lord, just to digress for 1 minute, apart from that bias, etc., which I had shown on the earlier occasion, I'm not reading again. Your lordship had marked it on the last occasion. Report of engineer for 1 minute, just to show, my lord, how exhaustive. It's my evidence. How exhaustive it is, and what kind of, my lord, study went into it. হ্যাঁ দেখাবো তারপরে দেখাবো এক এক মিনিট
6798
Lord, page 6798, volume 41. And volume 42. My lord, this is our evidence. Ken Wong, my lord, who was in charge of GC after analysis, this is his evidence really. He would have, had there been evidence, he would have proved this. Now, my lord, please see from 804, 6804. And I'm not going to read it, my lord. Expected ground condition at 6804 with all evidence. Expected water condition 6807. Then, my lord, full of data. And page 6823. Was the water which was encountered foreseen? So he says this was foreseen. Then what ground conditions were expected? That's on the next page. So this is all to show it's not unforeseen. Then 6826 pilot TBM. Then entire explanation on TBM and what was discovered with pilot pictures at 6838 on of the grease ports, etc. And mathematical calculations, ultimately pilot 6848. Before that, I'm sorry, let's, for example, 6846. So, my lord, he's analyzed, lord, the curves, etc. And was it properly handled or not? Otherwise, a bolt would have come out. A lot of, my lord, engineering in this. Then 6842 is how TBM should be steered, why it was not steered, with diagrams, etc. Now this, and
পেন দিয়ে দেখাচ্ছি না পেছনে জল ঢেকে গেলে এই যে ব্রাশটা যদি থাকে ভয়েড যদি জল না থাকে তাহলে
6831, my lord, I should have also shown, is failure due to insufficient grease, or everything is there. Now this is, if I now come back to the award, based on, my lord, these 8 or 10 paragraphs, none of this is considered. And IIT Shibpur looks at, my lord, the disturbed soil samples after retrieval, and their report, my lord, is at 7141, volume 43.
Are these pages mentioned in your argument?
Yes, it is mentioned in the note. Very well, my lord. After seeing everything, they, my lord, discuss soil, and they say that it's not possible for raising this sort of an argument, which, my lord, is countered by the arbitral tribunal by saying that we are engineers and one of us is a soil expert. One sentence.
Yes.
No, this is this is the award. Now, on the claims. Oh, I'm sorry, my lord. Now, my lord, I'll show your lordship that there are clauses in the contract which bar the arbitral tribunal from awarding the claims which have been done. আমাদের একটা জায়গায় সবকটা সেট আউট করা ছিল notes of argument. My lord, kindly, my lord, take our notes of argument file before the learned court below, the arbitral tribunal. Yeah, I'll just, upon insistence, I'll just read out the observations of IIT Shibpur.
Yes.
The pre and post retrieval soil investigation reports have been reviewed and soil samples collected from the TBM, Cutterhead and tail seal locations have been analyzed. Based on borehole data and laboratory test results, soil profile has been prepared. Atterberg's test limits as well as grain size data have been plotted separately as well as combined with present investigation. This report contains photographs of disturbed samples collected during such and such. Based on the review, the following may be concluded. Detailed soil stratification could be made with the available borings after incident. Zigzag location of boreholes helped in identifying soil profile exhaustively. It is revealed from all exploration reports soils available at the tunnel alignment level are predominantly sandy silt with very low plasticity or non-plastic in nature. Which will not, if there is low plasticity, water cannot accumulate and make a table or something like that. It is porous, it will flow through. And there is no major variation in soil properties between those reported at stages and present samples collected. So no unforeseen. Now, just Milord, to show your lordship those few clauses, volume 73, which your lordship was seeing. At page 11533. This is my notes of argument before the learned arbitral tribunal. This is ignoring the contract. Milord, survey and protection of site and works, onus upon the contractor. These are the clauses. So the contractor has to survey the site and he has to protect the site. Then, Milord, page 11539 is loss, damage, reinstatement, contractor's responsibility. These are the clauses. Some 10 or 15 clauses which makes him responsible for everything. These have all been ignored. Then page 11547, soil investigation, design and assessment, contractor's responsibility. So, under the contract, he should know what is the soil condition, what is there below the earth. Then, tunnel boring machine operations and tunnel boring machine contractor's responsibility, 11554. All these clauses. Then, Milord, 11556, risk and liability of the contractor. So, Milord, none of these clauses have been taken into consideration. This is notes of argument. I read out this to the arbitral tribunal. Now, and Milord, if your lordship sees the notes, it has what I have argued, it has the same thing exhaustively written. All the reports, his reports, why should they not be considered, etc., etc. Okay. Now, Milord, kindly come to 11597. I'm sorry, 11598. The next page, Milord, 11598.
Yes.
Arbitral tribunal is prohibited from awarding damages in view of 8.3 of GCC. Those are those no damage clauses. Given, judgments given, not dealt with. And now, Milord, see award of claim. Milord, kindly now come back to the award. How, Milord, claims are awarded? From, Milord, page 90 of the award. 4 points, Milord, I'll make. Number 1. All my claims rejected. Most of his claims allowed. Now he says, the learned arbitral tribunal says that for part of the claims, you can get the money from insurance company. Now, why part? Why a part? Why not the whole? How can you say this? Insurance company is not a party. And there's a direction upon me to cooperate.
With whom? The insurance company.
With him and the insurance company. Half of it, well, some of it. But why some? Why not whole? Or why any? Nothing. Next is, insofar as quantification is concerned, it proceeds on the basis that just because of that procedural order where we will not said probative value has to be decided, he says that now I'll look at everything and I'll accept everything. And you, the respondent, have not objected. Though in this statement of defense, there is clear objection, which I will show. So, what is the basis? Thirdly, where you're giving 80% of a claim, why are you giving 80% and why not 75 or 65 or 100? That's absent. Next is declaratory relief, that in respect of this contract, for the future, everything will be payable, which is A, beyond the scope of arbitration, B, beyond the scope of the claims, and C, it's a declaratory award for money.
No, everything else will be payable means?
For example, in the future, whatever costs are incurred have to be paid for rehabilitation of the tunnel, etc., for the future. Because even now it's going on. Even now it's going on. Then this is not resulting in one after the other. We're defending 3 more arbitrations based on this award. And they're saying you can't deduct any money, whatever is there, there's a declaratory award, you have to keep paying me. So declaratory award for money for the future. And ignoring, my lord, my objection. My lord, may I now quickly take your lordship to, I'm sorry, my lord, page 91. So, my lord, there are 3 or 4 series of claims. So, claim A1 starts from paragraph 127. I'm sorry, I just missed a paragraph. On the insurance, paragraph 122, before I come to 127. Same page, not on the other side. In the detailed hearings of both the sides and after studying the evidence presented before the AT, it is clear that there is nothing to firmly prove that the incident of 31st August took place due to acts of commission and omission on the part of the claimant, as also there is sufficient proof that it is more a case of unforeseeable physical situation, and the same has to be treated under 4.23. At the same time, clause 4.1 and 4.2 of the contract agreement have importance, and accordingly 2 sets of clauses together come into play that claimants cannot be held responsible for the incident. So they are not responsible, unforeseeable. Therefore, they cannot be made to ask to bear the losses that took place in the near vicinity of the incident, such as the cost of shifting, rehabilitation, etc., as per clause 4.23. But at the same time, the respondent cannot be made liable for the expenditure that the claimant contractor has to make to retrieve the plant machinery and restart the work. And both the parties should cooperate and work jointly in order to claim the same from the insurance company. Now, after this, he's been taking out money from insurance, I presume. When I write to him, he doesn't tell me. The matter is pending, please let me know. He doesn't indicate how much he's got from the insurance company. That's Millard part of the records. Now, Millard, kindly see. 127, claim A1 to A6, all they're dealing with together. A brief discussion. Now kindly see, Millard, respondents' rebuttal to these claims at page 94. Where have we dealt with A1 to A6 in SOD? Respondents' rebuttal, first paragraph towards the middle. Denied omission, etc., etc. However, no comments or pleadings as far as quantification of the assessment of claim without prejudice to their principal argument has been given. Accordingly, AT will rely upon its own assessment to arrive at the quantum of the claims. The respondent has further pleaded that even if the claimant has incurred any loss, respondent is not liable to reimburse the same. Now please see the assessment of AT. AT has gone through the averments, submissions. AT has not agreed with the respondent and has accepted that the expenses are payable to the claimant subject to modification. No charges for machinery, no overheads, etc. Then C, AT has opined that the claimant has to be reimbursed actual cost incurred, but the same should be claimed from the insurance company against the car policy and not from the respondent. Then 3 lines down, accordingly, claimant and respondent should work jointly and get the amount reimbursed from the insurance company. Then all of it, Millard, work jointly insurance, half of this. So A1 to A6 is nil.
Felt bad after passing the award.
Felt bad.
Bad for you.
Yes.
So that you can
So nil.
at least from the insurance.
So nil, insofar as I am concerned, paragraph 129, A series claims, but full against respondent, full against insurance company. Get it from the insurance company. And we have to work together. Oh, the whole of it. So claimant will get.
No, 129 I don't understand.
Accordingly, the total amount of claim allowed to the claimant against claim A1 to A6 works out to be nil against the claim of 4.5 crores. And the same is accordingly awarded. So nil award. But the observations under each claim.
Was the total claim?
No. This is just one series. Now, but the observations against the total claim.
Yes.
Is insurance company and I have to cooperate. So effectively, claimant, it's been awarded, claimant doesn't get it from me, but will get it from insurance.
The insurance company should also have preferred at section 30.
I don't know what they are doing because no, this is unbelievable.
Execution case has been filed.
I'm sorry, Millard.
Execution case has been filed. This award?
For this?
For this?
No. 70 crores is what is against me. I have deposited 70 crores. But the danger, Millard, is the interest, and the danger is, Millard, the other claims which are coming and will keep coming based on this observation, this finding. So it will go up to upwards of 500 crores. Then, Milord, please see paragraph 130. This is Milord shocking. Paragraph B. The claim has been computed based on the actual. Oh, dispute No, I'm sorry, Milord. Just C30 তে আসার আগে ওটাতে ডিসপিউট করেছি দেখাবো তো আমরা।
8435 crores.
হ্যাঁ।
Later we have denied it at page 6196 of SOD.
Milord, there were in the arbitration, one thing I didn't point out in that A series claim which have been awarded nil is that they say that there is no comments or pleadings as far as quantification of the claims is concerned. Milord, this is at page 94 of Milord, the award. A series claims which have not been awarded against me, but Milord have to come from insurance. But no comments or pleadings, so quantification is accepting. Milord, in my SOD, where I deal with the quantification, I want to show your lordship that we have disputed it. Statement of claim has, Milord, a list of updated claims which they were given liberty to file. So we've disputed. I'll show your lordship. I'll just read out and give the
paragraph number. Yes.
and give the paragraph numbers.
The volume and the pages.
Volume 37,
Volume 37,
paragraph 90, 6190.
paragraph 90, which starts at page 6190, at page 6196.
Annexure C30 to dispute A amount to dispute. This is the total of all the claims.
The purported claim of the claimant amounting to 84 crores or any part thereof does not have any basis or justification. Claimant is not entitled. Method of computation is false, incorrect. It is denied that claimant can make any claim on account of any costs or that purported costs or should have been justified. Methods of computation and details provided in Annexure C30 are false and incorrect and are denied. Claim numbers A1 to D18 do not have any justification or basis, misconceived, unable, baseless, untenable, baseless, usual denial, false, incorrect, denied, disputed. Now, so the A1 series is said no comment. Now, if your lordship comes to.
No, you have denied. You have not quantified anything. I mean, there's no scope of you quantifying.
No, I'm disputing it. But Milord, please see the.
He says no comment. The tribunal says, however, no comments or
So,
pleadings as far as the quantification. That means also no denial.
no pleading as per quantification of the assessment of the claim. So I'm saying it's misconceived.
So the AT will arrive at its own quantum.
Yes, but where is the conclusion? So when your lordships will not allow claims, say if I allow 100 rupees, you have to come to a conclusion based on the documents and the evidence that 100 rupees, this is my quantification. That's zero. Now, my lord, what is shocking is paragraph 130. B at page 97. The claim has been computed based on actual cost incurred by the claimant. Actual cost incurred by the claimant. Details of which have been provided in Annexure C30. However, while computing the claim, usual overhead and profit has been considered. Respondent has pleaded. Claims have no justification and method of calculation is false. Moreover, if the claimant has incurred any costs, respondent is not liable to reimburse. Then, next page, last two lines. However, this damage cannot be attributed to the respondent. Accordingly, this amount should be claimed by the claimant from the insurance against the car policy. and respondent should support and cooperate with the claim. So, and that's not the same. B series, same. And everywhere, my lord, one sentence. Respondent has not commented on the quantification.
Not disputed.
So, my lord, what is happening? You make a claim that this is, my lord, costs incurred.
But these are awarded ultimately.
Yes, indirectly.
No, 132 last sentence. Accordingly, sum of such and such is due
Yes,
to the
part of it is awarded against me, part of it is against insurance.
next also 133 also. Everything is awarded
Yes,
against you.
this part is awarded.
B in its entirety is awarded.
No, B7 is insurance. Milord, at the top, Milord, B7 is
Only
insurance.
B7.
Yes, the rest are awarded.
Rest awarded.
So what is happening is, you say you have incurred this expense. You give a chart and call it C30. You give some third-party documents. Now what happens in these sort of cases is, the rate is approved. I admit rate is approved, but whether I have done this work is a question. Now what we argued in the arbitration is, say for example, 100 centimeters of grouting or digging or any other technical activity that can be for this part of the tunnel, that can be for that part of the tunnel, that can be at this time for remedial measure, that could have been done before, that can be done after. So when you produce a document to show that this is directly connected to this incident, you have to show how it's connected.
So paragraph 131 is the only assessment. I mean, there is no other finding anywhere else
No,
on these claims.
no,
The quantification.
no. But please see 131. That's all.
Apart from
130,
131, previously there is no discussion on the on what documents. you have to do.
130.
This is all.
This is all.
These are the only paragraphs.
Yes.
Starting from assessment.
This is the assessment. So he proceeds on the basis there is no quantification. There is no, my lord. I'm sorry. There is no comment on the quantification of the
Quantum
claim.
has been calculated only from page 90. I mean, assessment and award against the claims. Before
Yes.
that, there is no such, no discussion of evidence, nothing
No.
regarding the quantity, actual amount of loss suffered.
No, this is all. Now he gives profits also. I'm sorry, I keep saying he because subconsciously it is one of the members of the arbitral tribunal who is responsible for this award. 103. Profit of 10% disallowed, only overhead 10% allowed, cess 1% allowed. But why 10%? Why not more? And before that, my lord, at page 101, why 80%? And this is the only discussion. So, my lord, the claim proceeds on the basis, this is very important. Some work is done and you give a schedule. I deny and dispute the schedule. I don't have to do anything more. I say it's false, it's incorrect. It's for you to show. So the arbitral tribunal says that just by that won't happen. You have not commented on the quantification of that. I'll read out.
No, you have
I've read
disputed.
that, Milord.
You have
Deny,
disputed.
deny, disputed. Clear. C30 is
You have
this.
placed already. Yes.
So you say now that you have not commented on the quantification.
Very good. Yes.
And so therefore I'll take everything to be correct. Then the percentage on the quantum you give as per your own desire. And he starts, claims are started by this observation. At paragraph 126. AT will decide the probative value of the contents of the document. This agreed decision applies to the documents concerning the claims and counterclaims of the parties. There is a difference between, the learned arbitral tribunal does not appreciate the difference between appreciating the probative value and deciding the probative value and accepting the whole of the contents. So even if all of this had to be considered, the arbitral tribunal was obliged to consider the probative value, which it does not consider. You know, this is all expenditure concerning tunneling activity. Why for this part of the tunnel? Why not for another part of the tunnel? Where is the evidence? Where is the discussion? You're giving somebody 70 crores from me. You're giving somebody some further money from the insurance. And you're giving a declaration which will give the claimant another 500 crores. Is this the quality of the award? I ask myself the question. This can never, my lord, stand the test. Now, my lord, D series. And your lordship will look at, my lord, page 103 now. There is a chart given. The right, my lord, is the comment. This is, my lord, the reason. Profit of 10% disallowed. He should also be unhappy. Why disallowed? Then, my lord, B. Then, my lord, please see, my lord, B. 10% allowed for profit. Why 10%? And what about quantification? Gospel truth. Same. For some he gives 10%, for some he deducts 10% and gives the whole thing. I'm disputing your schedules. Where is the discussion? Then, my lord, please look at paragraph 137. Declaratory award to all costs and expenses which will be incurred in respect of all ongoing and subsequent work to be undertaken. That also part of it is insurance, part of it is me. So all decided. For the other arbitrations, it will be, see, I have award. Now just allow. No, this is, and then my counterclaims are rejected. That's yes. Third party liability has been awarded for them but rejected for us, which is contradictory. If it had been done for them, it had to be done for us. But that's a minor issue. Now, my lord, on section 34, I'll my lord, submit the judgments. I'm not going to read them. Please come to page 13, law applicable. I proceed on perversity.
Yes.
I proceed on perversity. I proceed on no evidence. I proceed on non-consideration of material on record, which is perversity. And Miller, I have analyzed and given the cases with the paragraph numbers. Shocks the conscience of the court, we have also covered. I'm not reading the judgments.
Usual judgments.
Usual. And ignoring contractual provisions. Usual judgments. But this is, your lordship not done. But it is improper to not come with the judgment. So
Definitely, why not? Usual judgment does not deprecate
usual
the value of
judgments.
those. Judgments are common. I mean, associate, Sangyang, ONGC.
But with this, may I just look at show your lordship, one paragraph from my note, which I think is important.
Yes.
Ultimately, my lord, after Sangyong, Lord, please look at page 14.
Yes.
Sangyong, change in law is considered.
Page 14.
Yes, of my note.
Yes, Sangyang. Yes.
Yes, Supreme Court examined change in law which occurred after Section 34 was
Patent
amended.
illegality, for patent illegality.
Yes, my lord.
This is for patent illegality being introduced. For that.
Yes, and my lord, Western Gecko, my lord, continues. Perversity continues.
Yes.
And this is argument is effectively
Perversity comes within patent illegality also. Perversity was not there previously.
But by judgment law, it was there.
Judgment law it was there, and now it has been brought in by way of patent illegality.
And contrary, ignoring contract provisions.
And 28.3 is also there.
28.3 is also there, which I have mentioned in my note. My lord, all these judgments, my lord, I'll make a, my lord, I'll keep it in a file with my lord's office. I've got them with me now. I'll give a copy to my lord.
Yes, yes, later.
And your lordship would have new judgments, my lord, really nothing. Now just
Scope.
Correct. Two, my lord, I have around 10 minutes. Two things my learned friends are insistent. Mr. Basu is insistent that I read clause 4.23 from the contract once.
Yes.
Because this is seriously fundamental, and I agree with him, seriously fundamental. If a contract says that something cannot be done, claim bar. First, I'll read 4.23.
Yes.
8.3.
I'm sorry, for 8.3. 8.3.
Delay.
8.2 is time for completion. 8.3 is delay.
You have a counterclaim on what?
Counterclaim on delay, counterclaim on, because all this has resulted in an overrun of years plus additional expenditure. We've paid crores as additional expenditure.
Compensation to third parties and all.
Yes. Say, for example, my lord, it's continuing.
Rehabilitation overhead.
Rehabilitation.
Overground.
Yes. So, under an interim order, my lord, we were being reimbursed with whatever payments had to be made to third parties. But they have stopped doing so. So now I am having to pay to all third
Who
parties.
reimbursed?
My lord, they were, my lord, putting in the money.
Achha.
By an interim order, which in the final order says that onus is upon me. So we have to pay for rehabilitation, we have to pay for reconstruction, we have to pay for, my lord, repair of the buildings, over 100 buildings. Then retunneling activity, lot of claims are there, my lord.
So 8.3 you're relying on.
Yes, 8.3, my lord, bars their claim for damages. This does not entitle the contractor to damages or compensation. GCC 43.
Yes.
Failure or delay by employer to the engineer to hand over to the contractor the site or any part of the works, or to give notice or commence works, or to provide drawings or instructions or clarifications, or supply material, plant, machinery under the contract is the responsibility of the employer, shall in no way affect or vitiate the contract or alter the character or entitle the character to damages or compensation thereof.
They have not asked for delay, damages for delay.
No, my lord,
They don't
they've
ask,
asked for,
they
according
don't
to us,
claim
the-
damages for delay.
no, they've asked for damages for whatever expenditure which has gone into it,
This does not apply to that.
which includes a component of additional costs also. Milord, no, Milord,
does not cover.
damages for yes, they have, and I'll show you a lot. Milord, they have loss of profit. That's for delay. There you go. Loss of profit is damages for delay. For the overrun period. Now, this ought to have been discussed by the tribunal, not done. Instead, my lord, it comes out by 4.23. This is number one. Number two, this is also, my lord, important.
Have you referred to all these clauses in your written notes?
My lord, regarding damages, regarding, my lord, criticism of the claims, it's not very well drafted. My lord, I'll replace 3 pages.
Not replace the place, file a new written notes over.
Now,
For the time being, I'm keep retaining this. For
yes,
the time being, I'm retaining this.
yes, this has
It should
everything.
be the structure, but over there.
Yes, I'll improve it, my lord. Now, they come to arbitration. I have, my lord, little over 5 minutes. I'll utilize it. My lord, just 3 reports of, my lord, their experts. I want your lordship. Now, last thing, they come to arbitration with this evidence. I just want to show your lordship
Their reports or your reports?
their reports. My reports I've perfunctorily shown. Their reports I want to show, and this is the end, my lord.
You have criticized. You say that half of them, one is based on newspaper reports.
Yes.
And all this.
Now, my lord, kindly come to volume 3 of the petition. Of the of the compilation. Compilation, sorry.
Yes.
This is, my lord, Charles Mann's report.
This is Man Ki Baat. Yes.
Man ki baat. My lord, page 430. Description of drive, TBM driving experience, settlement analysis, then geological assessment at 431.
Yes.
As mentioned in soil investigation report, artesian condition was observed. Wrong. Then analysis of soil sample at page 432, and then page 433, incident conclusion and opinion. From the information given during my visit to the site and talking to key people and research into the incident, following conclusions can be assumed. TBM operating parameters during the drive before the incident were controlled, routing such and such.
Now, who is the author of this report?
Mr. Charles Mann.
Who is he?
He is, my
That's
lord,
supposed an expert in the field.
he's he engaged by them as an expert,
Where does the report
tunneling
start?
expert.
Report starts
Starts at 426, 425.
All right. Yes.
This is the covering letter.
Yes. Yes.
Then conclusion is this.
Hmm.
And then 434.
Creek Road.
In addition, historical information indicated underground water flow from a river And this can be confirmed in one report. See Appendix 8. That is some newspaper article. History, everything is being, the history is being destroyed. And this is pre-retrieval. No, there is a difference between something like this and the 3 reports which I showed your lordship, exhaustive, with data, with calculations. Now, second report, which is GeoConsult, which is at page 539 at volume 4.
Yes.
Where 539 starts. All this is below garnish, geological boundary conditions, etc. Then page 548, data review and probable failure model. 5.1, since the sand layers are not uniformly dense, it is assumed to be a pocket of loose sand. And then concluding remark at page 552. That's all. That's the end of his report. All pre-settlement. And Herenschnett, the TBM manufacturer, gives a 2-page report. Conclusion is at page 615. So it's very clear that the exact cause of the incident is unknown to us. We could not find any fault with TBM. Neither do we find any fault with the TBM. It's Miller, there's nothing wrong with this TBM. It's the steering. There's nothing wrong with my car. I will not have an accident because I can't drive well.
This is nothing.
And I'm grateful. Miller. These are my humble submissions. The affidavit in reply.
Yes.
May I just put it on
the affidavit in reply filed to be kept on record. Hard learned counsel for the petitioner. Push up for arguments of the respondent. Let the matter stand adjourned till November 22, 2024.
And I'm filing my affidavit in opposition.
আচ্ছা যেখানে affidavit in reply filed to be kept on record বলুন affidavit in opposition and affidavit in reply filed to be kept on record এইটা না একটুখানি এটার সঙ্গে স্টেপল করে দিতে হবে এই রিট নোটসের সঙ্গে
Grateful.
Note हो यार Court number 16, na? Sabyasachi petition. बैठे नहीं पता नहीं बैठेंगे कि नहीं जी
Yes, yes, sorry.
My lord, may I be permitted to mention contempt application, my lord?
Yes. Jalpai. Jalpai. Yes. What is the matter?
My lord, Jalpaiguri matter, my lord, I am appearing for the petitioner in the civil revisional application.
Yes.
The recalling application has been filed by the opposite party.
Yes, your lordship. Party?
Yes,
Opposite
lordship,
party.
am I audible? Yes, your lordship, I'm pleased.
Yes. What is the recalling ground for recalling?
Your Lordship, the order that was passed by the appellate court, Your Lordship, there was an observation for a retrial, Your Lordship, but there was no in the observation there was no elaboration whether the previous evidences should be deleted and the new should be added, Your Lordship. So if the order was set aside and observation was passed for setting aside the order, Your
Please
Lordship,
come to
if
page
the
please come to paragraph 15 of the order under recall. Please read it out.
yes, Your Lordship.
Please read out the last para 15.
But is this a ground for a recalling application,
No,
Lordship?
let me. Yes, please
Your
place
Lordship.
para 15, ma'am. We are waiting for you.
Yes, Your Lordship, again, Mr. Dr. Chaudhary is appearing. He is in
Whoever is appearing, read out para
physically.
15. Read
That's
out para
why.
15.
Yes, Your Lordship.
Read it out aloud.
Yes, Your Lordship. Yes, Your Lordship. It was allowed, Your Lordship. Para 15. I apologize, Your Lordship, for the delay. Yes. Accordingly, serial number 106. May I read, Your Lordship?
Yes, I am asking you to read. For
Yes.
this is the thrice.
Accordingly, yes, Your Lordship, I apologize. Accordingly, CO number 106 of 2023 is allowed, thereby setting aside the order number 86 dated May 16, 2023, passed by the Civil Judge, Junior Division, Additional Court at Kuch Bihar, further and directing the trial judge to proceed with the retrial on the basis of the evidence which was already on record before the remand order and to decide the preemption case on the basis of evidence already on record as well as the further evidence subsequently adduced as expeditiously as possible, preferably within 6
What
months
is the
from the date
difficulty
of
in
commencement.
understanding this? That it will be on the basis of evidence already on record, and if further evidence is adduced.
Actually, we prayed for recalling because when we were served after the matter was heard ex parte, Your Lordship. That's why we were preferring an recalling application, Your Lordship.
When were you served?
The affidavit of service was
I have,
filed, my lord.
yes, Your Lordship. I have been instructed by the client that they have received it after the matter was heard, Your Lordship. That's why I prayed for an recalling, Your Lordship.
Yes, Sneha, what do you say to that?
My lord, I have filed the affidavit in service. Lordship, kindly see the order, the first line of your lordship's order, where your lordships have stated, despite service, none appears for the opposite party. Affidavit of service filed today be kept on record. Now, my lordship, the order which has been passed, where your lordships have specifically stated the earlier evidence as well as the additional evidence. So, my lord, my humble submissions before your lordships that they have given opportunity, not that they have not given opportunity. They can
yes, we are dismissing the application. I'm giving the reasons. Order to record.
Lordship, one opportunity may be given to hear it on merit, Your Lordship.
The recall application, sorry, the recall application has been filed on twofold grounds: niche Roman 1, that it is not clear from the order under recall as to whether the evidence which is already on record requires to be expunged or the matter should be heard on the said evidence. Full stop. Roman 2 niche paragraph, that the revisional application was served on the opposite party in the revision within bracket present applicant bracket closed after the order under recall was passed, comma, as such preventing the opposite party stroke applicant from from contesting the matter when the same was taken up by this court. Full stop. Next para, learned counsel for the revisionist petitioner stroke present opposite party opposes such contentions and argues that these are not grounds for recall as recognized by law. Full stop. Next para, in fact, comma, a bare perusal of the affidavit of service which is a part of the record, comma, which was filed by the revisionist petitioner in connection with the revisional application, comma, shows that the postal track report clearly indicates that the item was delivered to the addressee within bracket present applicant bracket closed on September 18, 2023, at 14:29:28 hours. Full stop. Next para. The order under recall was passed on September 22, 2023, comma, that is 4 days thereafter, comma, thereby belying the contention of the applicant that the applicant did not receive the copy of the revisional application prior to the date of the order. Full stop. Next para. Also, comma, in the said order, comma, it's clearly recorded that despite service, none had appeared for the opposite party within bracket present applicant, bracket closed. Next para. Insofar as the other ground of recall is concerned, comma, the same also cannot be accepted, since in paragraph number 15 of the order under recall, comma, the court specifically observed that the revisional application was allowed, comma, setting aside the impugned order and directing the trial judge to proceed the retrial, italics se debe, on the basis of the evidence which was already on record before the remand order, and to decide the pre-emption case on the basis of evidence already on record as well as the further evidence subsequently adduced. Italics shesh, full stop, Next para. Thus, comma, none of the grounds taken in the recall application are tenable in the eye of law and in facts, full stop. Accordingly, can 1 of 2023 is dismissed on contest without, however, any order as to cost. Thank you.
Gratefully, Your Lordship.
The Port Blair matter.
Lord, I appear on behalf of the
My lord,
respondent.
I am appearing for the respondent, my lord.
SLP has been admitted, my lord. The notice has been issued and
No,
Yes. Mr. Chakraborty has been admitted.
Yes, no, admitted, my notice, I wouldn't say admitted, my lord, yet, but notice has been issued, and my lord, the Supreme Court has requested your lordship to adjourn the contempt.
Very well. Learned counsel appearing for the alleged contemner submits, comma, by handing over a copy of an order dated September 27, 2024, passed by the Honorable Supreme Court in connection with SLP within bracket C number 22189 of 2024, comma, that notice has been directed to be served in connection with the said SLP, and it is observed in the order that in the meantime, comma, the contempt proceedings which are being instituted against the petitioners in the SLP before the High Court shall stand adjourned for the present. Full stop. In view of the said direction, comma, the contempt application is adjourned sine die with liberty to the parties to mention for inclusion in the list as and when further orders are passed by the Supreme Court and or the SLP is disposed of. Full stop. Goes out of the list for the present. Please inform
My
the
lord, my lord, my lord. Most
grateful. Sorry, Mr. Garin. I have given detailed reasons. You go through that. Thus, there is no scope of interference in the order under review. Accordingly, RVW 310 of 2023 and RVW 185 of 2024 are dismissed on contest without an order as to cost. Consequentially, all connected applications bearing CAN 2(1) of 2024 are disposed of. As a result, RVW 184 of 2024 and the connected application bearing CAN 1 of 2024, having been rendered academic in the light of the earlier part of this order, stand disposed of as well. Urgent certified copies.
So kind of lush.
Thank you.
Should I pray for a stay of the
after later will add later learned counsel for the review applicant in what is your RVW number?
184, 185.
184 and 185 both are yours?
Yes, Lordship.
Review applicant in RVW 184 of 2024 and RVW 185 of 2024 seeks
2 weeks accommodations for
a stay of 2 weeks of the above order, pushed up in order to enable the said review applicant to prefer a challenge, comma, a stay of 2 weeks of the operation of the above order is hereby granted.
So kind of flush.
That will be a part of the later part of this order.
So kind of flush.
Thank you. Five yes.
Petitioner, my lord. My lord. My lord, I appear for the alleged contempt number.
Yes, yes.
Lordship,
This matter was.
I'm led by Mr. The learned ASG.
Yes, yes.
Lordship, I'm appearing for the Union of India.
By your lordship before the vacation.
Yes.
We produced a copy of the order of the division bench, which was a request to your lordship not to take up the contempt application.
Yes.
Now, lordship, after perusal of that order, had been pleased to place this order matter today, and before vacation it was heard at length before the division bench.
It's still pending. Yes. Good. Learned ASG hands over a copy of an order dated September 24, 2024, passed by the division bench in connection with the appeal against the parent order, wherefrom it transpires that the learned advocate appearing for the writ petitioners stroke present contempt applicant had undertaken before the said court that they would not proceed with the contempt petition filed before this court. Full stop. The undertaking was placed on record and hearing of the contempt application was deferred till the appeal is heard and disposed of. Full stop. Next para. In view of the above, comma, the contempt application is adjourned sine die with liberty to the parties to mention for inclusion as and when the appeal is decided by the Honorable Division Bench. Thank you.
Here, appeal contempt number 2, straight up.
Please, yes. Thank you.
Item number 6.
So you're appearing for the petitioner.
Have you served on the other side?
Yes, sir. Activity of service.
No, there was a direction for service probably. Yes, yes, directed to sir. You have served properly. What is the nature of the contempt?
Lordship, that in this matter, your lordship was given direction upon the BDO and block land and land reform officer. But I have instructed.
Please take the yes. You have been instructed.
Till date, they did not take any single steps.
Let me see the order which was passed.
In page number 21.
21.
21 in contempt application. Second paragraph, lordship. May I read this?
Yeah, I'll read it. You just wait for a half a minute. In the order dated January 3, 2023, passed in WPA 4175 of 2022, comma, this court had directed the alleged contemners to implement the order of the district magistrate as indicated therein above immediately, and the respondent number 6, police officer in charge is also one of
respondent number 6.
Respondent number 6 therein, comma, one of the other contemners was to act upon a server copy and immediately grant police assistance to the other 2 respondents as named therein above in implementing the said order of the district magistrate, comma, thereby demarcating plot number 1074 and after such demarcation, comma, to ensure that the path is made fit for free movement of the public in the area. Full stop. The entire exercise was to be completed within 3 weeks from date. Full stop. Next para. Despite service of copies of the contempt application, comma, the alleged contemners neither appear in court nor are represented through counsel when the matter is called on for hearing today. Full stop. Since there is palpable prima facie evidence of willful and deliberate violation of the order of this court dated January 3, 2023, comma, a rule to issue in terms of the prayers made in the contempt application, asking the alleged contemner to show cause as to why penal action as per the prayers made in the contempt application shall not be taken against them. Full stop. The rule is made returnable on December 13, 2024 at 2 p.m. তার affidavit of service file to be kept on record.
Item number 7.
This is my application for contempt.
So also this is appearing for the first, or you have served?
Not, no.
No
Because it is
service
yet
was-
to be admitted, my lord. That the prayer was defective. My junior, my lord, came and my lord, he submitted, my lord, leave was granted to file a supplementary affidavit annexing certain documents, and the
Your
prayer
friend.
was not in consonance of the Contempt High Court rules, Rule
Acha.
4, Rule 7, how the act of contempt has been committed. My lord, your lordship directed, my lord, the authority to complete the execution proceeding. My lord, execution proceeding has to be completed and it must reach its logical end within a time frame.
Execution case in connection with
In
what?
connection with the certificate proceeding initiated under Miller, the Bengal Public Library Corps.
It was to be done within a limited period.
With limited period.
Not
And
done.
Miller, no. And Miller, the check that was submitted in pursuance of the order passed by the SDO,
Yes.
Miller, that this was bounced. And Miller, ultimately the order, Miller, could not be given effect to.
So I'll direct you to serve copy at the first instance.
Yes.
Since a prima facie case of contempt has been made out by the petitioner, comma, the petitioner shall serve a copy of the contempt application along with a copy of the supplemented affidavit which is filed today, indicating that the matter shall be listed next on December 13, 2024, when the petitioner shall file an affidavit of service to that effect. Full stop. The supplemented affidavit filed today is kept on record upon leave being granted to the petitioner to file the same.
Deeply obliged.
Item number 8.
Lord, I beg to appear for the
Yes.
petitioners. my lord.
They appear on behalf of the alleged contempt, your lordship, the reply.
রিপ্লাই আমি পাইনি এখন পেলাম হ্যাঁ
Reply to the rule was issued.
No, your lord.
Rule was issued.
Yes, 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 yes.
Issued, your lordship. Affidavit of compliance was.
my lord, this is how my lord the contemptor has been doing.
Let me hear.
Yes.
What is the nature of the contempt? Please
Nature
just-
of the contempt, my lord, these persons are immunization volunteers.
That,
Yes. They were getting 90 rupees a day. They ought to have, my lord, they received around rupees 550 a day. Pursuant to a lordship's order, that order was carried up in appeal. Appeal court upheld the order. Subsequent thereto, what they have done is they have paid certain meager amounts. Now they are saying we have not worked for 26 days a month, but we have documents. This is how they are trying to play fool with the court. I'm very sorry for using this term, but they are practically trying to play fool with the court.
Let us just once see the order, initial
Yes.
order.
Now they are saying that we have not for 26 days a month, but I have registered as of now, I have 2 persons, they are registered, which says more than 26 days a month even.
Just let me check up my order. I mean the High Court's order. What is the December 8th order? Have you annexed that? Because that was the premise of
Yes, my lord.
this order. Yes.
Lordship,
Have you got a copy of that? Either of you?
I've annexed it to my reply, your
To a
lordship.
reply.
Page 9. The typed copy is at page
Yes.
10, your lordship.
Yes.
And they are saying fail to produce a document wherein 26 days. It is for them, they can easily see we have the register, attendance register. 2 of these persons I have. I have all the photocopies of this. More than 26 days a
We have
month.
annexed all the documents pertaining to the date, how many days they have worked in a year. They were paid the amount, what amount they were paid, and what
In
is
the reply,
balance amount.
reply.
In the compliance as well as in the reply, your lordship.
I have given an opposition to
Your
my
lordship will
complaint.
kindly see page 11, your lordship.
Of?
And of the reply. And in the opposition, they have not denied any of the computations, your lordship. Your lordship will kindly see their
I
opposition.
have. Yes.
The paragraphs are mere denial and they have annexed only representations.
Kindly see the representations annexed to the oppositions.
Mr. Bhakti, use an affidavit to this also. because they have annexed something. Have you got a copy of the reply now?
Your Lordship,
Yes.
the detailed computations have already been annexed in the compliance.
Compliance also.
Yes, yes.
Yes, I have used an opposition to that
Look into that.
compliance.
Look into that.
But these documents were never disputed or
No.
dealt with, Your Lordship.
Which page of the compliance?
Your Lordship will kindly see from page
Oh, all the documents.
13 onwards, Your Lordship. All the documents.
In the opposition, they did not deny.
Your
Yes,
Lordship,
I have.
made denials, Your Lordship. They have not dealt with the calculations.
Mr. Bakshi, we cannot go into a new fact-finding inquiry because the direction was to pay the balance at the rate of 550. They paid at the rate of 550, but the number of days is in dispute.
No, my lord, kindly considers a person ought to have got, my lord, more than 7 lakhs. They gave them around 1 lakh.
That is a
1 lakh.
contention. That is a contention, but they have annexed several documents and there is no counter document. I mean, to.
Yes, I have. My lord, kindly
me
sees
for my
the opposition. Kindly sees the representations annexed to those oppositions.
There are representations.
Yes, my lord. These are the representations that I've annexed. I've denied it and my lord, I've annexed. This representations are appended to the compliance.
Your representations are your version of the matter.
No, my lord, I can, if your lordship permits, my lord, I'll submit another affidavit. I'll place another affidavit, my lord, in the form
What
of an
will you
affidavit.
annex there? I was wondering
My
that.
lord, because 26 days they are disputing, but I have attendance registers to show that even more than 26 days I have worked.
Attendance register, you have extracts of that?
Yes.
But you did not annex that with your opposition.
I didn't have those at that particular point of time. We subsequently.
Very well.
Before, in the writ petition.
No, because that matter completely violates.
But you are directed to pay the balance. So balance, we'll have to look into at least prima facie whether we can decide the balance days.
Yes.
Learned counsel for the alleged contemners, one or several. Alleged contemner files a reply to the rule issued, which is kept on record. Full next para. It is contended on behalf of the alleged contemner that all due payments have been made in terms of the order of this court to the petitioners. In support of such contention, learned counsel for the alleged contemner places reliance on the documents annexed to the reply as well as the affidavit of compliance. Next para, it is submitted that in their opposition to the affidavit of compliance, the petitioners have failed to rebut the documents annexed to the compliance by cogent documents. Next para, learned counsel appearing for the petitioners disputes the contentions of the alleged contemner and submits that several days payment has been withheld. Next para, it is submitted that it will be clear from the representations made by the petitioners before the alleged contemner that further amounts are due for more days on which the petitioners worked. Next para, at this juncture, learned counsel for the petitioners submits that the petitioners have subsequently had the occasion to be in possession of the extracts of the attendance registers, which would indicate that the number of days for which the petitioners worked, as per the version of the alleged contemner, is erroneous. In order to give such opportunity to the petitioners to bring on record those documents, leave is granted to the petitioners to file a rejoinder to the affidavit in reply filed today by the alleged contemner. Such rejoinder shall be filed on November 22, 2024 with an advance copy thereof on the learned advocate on record appearing for the alleged contemner. The matter be placed for hearing further on November 22, 2024.
But one more thing, my lord, I have pleaded in my writ petition also that we have worked for a month. It was pleaded in the writ petition also. Well, that was never controverted.
Very well. Bring on the record those and along with that point out the writ petition.
Yes. I shall. I'm deep.
Point out that also on
yes,
and
yes.
Just indicate in your rejoinder that paragraph number of the writ petition.
Yes.
So that she can come prepared on.
Yes. I'm deep.
Number 9.
Yes.
earlier occasion, Your Lordship had passed an order on 23rd of August 2024.
They handed over some documents saying that
My
they have
lord.
complied.
They had contended before the court that they have complied with the order, but upon perusal of the entire records which were placed, Your Lordship was of the opinion that it was not visited by them properly, for which a direction was given to give a personal an opportunity of personal hearing, which was done. Now, my lord, the facts and figures which were placed before Your Lordship, pursuant to which Your Lordship had given a direction upon them to comply with the order, that has not been done in the true pith and substance of, my lord, the issue. This is the order which was passed by them pursuant to the personal hearing that was given. The figure which was placed remains the same. The bank was the corporate broker who made me get this insurance take up to cover up the loan which I had taken from the bank. My shop got gutted in fire.
But Mr. Jha, they have given reasons, whatever may be the worth of the reasons. But you have
This is just Your Lordship, upon perusal, Your Lordship will prima facie find that this is an eyewash, because I have documents, because the fire authorities, they have given documents which categorically state that stock worth 33 lakh has been destroyed in fire. And that is on record, my lord. And when that fact is on record and based on a private valuer, they have undervalued the entire thing. Stock worth 33 lakhs were there. My due to the bank was around 34 lakhs. I could have paid up that amount had the insurance company paid me the claim amount. And the bank was the corporate broker in order that I take up this particular insurance. And in a most unfortunate manner, the bank has sold the property, despite the pendency of this particular hearing, my lord. I have taken that issue before the concerned forum, my lord. Bank takes me up to take this insurance. I take that. They do not give the proper valuation. Well, I have
the
documents,
original order.
I can place that documents by virtue.
No, my original order. Where is that? What is the date of that order?
My lord,
the order under contempt.
Order under contempt is at page
30th November.
My lord, page 52 of the contempt application, your lordship.
52.
52. It starts with 52 and
yes,
right. Because that was categorically what your lordship had stated in the order. May your lordship take up from paragraph 10 at page 57, your lordship. Page 57. Because these aspects were visited by your lordship while passing the order regarding what fire company had stated. And pursuant to going through those facts, your lordship had given a direction, finally, to...
But they say you have not furnished any further evidence or any other...
It was furnished, my lord, my most humble submission.
Furnished?
It was furnished, my lord.
We prefer a challenge under a writ petition, Mr. Jha.
Well, the whole difficulty I am in is my property has been sold by the bank.
Previously, it was only stated that, which was set aside, that they had stated that after 4 days of incident, local shopkeepers don't know you and all these ridiculous things. After fire, it took some garments and all. Now they have decided. Good, bad, indifferent, they have decided. They say no new evidence or further documents.
Pursuant to the order passed by your lordship on 28th.
No, this is also legitimate. They rely on the surveyor's report by saying that apart from that, no further document was given by you.
The fire authorities had already furnished a report which were with them, which categorically spoke that stock worth 33 lakhs were burnt, my lord.
It cannot be decided in contempt. Learned counsel for the none appears at the time of call on behalf of the alleged contemner. The learned advocate appearing for the petitioner hands over a copy of a purported adjudication by the alleged contemner dated September 13, 2024, wherein it is seen that the claim of the petitioner has been refused by the alleged contemner on certain grounds. Push up next para, learned counsel for the petitioner contends that the said order is a mere eyewash. Full-stop, it is submitted that despite several documents and materials having been furnished and available to the alleged contemner, those were not considered at all in turning down the prayer of the petitioners on the flimsy pretext that no new evidence or further documents were furnished. Full stop. Next para. A perusal of the said order dated September 13, 2024 indicates that the alleged contemner has decided against the petitioners on the observation that the assessment made by the surveyor was after considering documents and particulars furnished by representative of Messrs. Rajnandini, and that no new evidence or further documents were furnished, comma, for which the surveyor's report was relied on by the alleged contemner. Push up. Next para. Whatever may be the legal or factual worth of the said decision, comma, fact remains that pursuant to the order of this court, comma, a personal hearing has now been given and a decision taken by the alleged contemner on the issues involved in the writ petition. Full stop. Next para. Hence, comma, if the petitioner is for one petitioners are further aggrieved by the order dated September 13, 2024, comma, it will be open to the petitioners to challenge the same in an appropriately constituted writ petition. Full stop. It is beyond the scope of the contempt court to adjudicate the merits of the matter and or come to any elaborate findings on the legal worth of the adjudication dated September 13, 2024. Full stop. Next para. In such view of the matter, comma, this court is of the opinion that no useful purpose would be served in keeping the rule or the contempt application pending. Full stop. Accordingly, WPCRC 79 of 2024 is discharged and WPA 22596 of 2023 is disposed of by granting liberty to the petitioners to challenge the decision of the alleged contemner dated September 13, 2024 in a properly constituted challenge, comma, if the petitioners are aggrieved against the same. No rest to cost. Thank you.
Much obliged. May I take back this copy, my lord? Because
I've recorded it.
This is the original one, my lord.
Give a photocopy then.
Well, I'll take and give a photocopy. Do
it immediately.
Immediately, my lord. I'll do it. উপরেই আছে একদম উপরে আমি এক্ষুনি কপি দিই much obliged.
Yes.
My lord, last time the alleged contemner appeared before the landed court, it was adjourned, but kindly dispose the case today in accordance to the prayer and the law.
Lordship, the appeal was appearing before Honorable Chief Justice on 6th November.
Yes.
I am led by Mr. Amitesh Banerjee, Learned Senior Standing Counsel.
Yes.
I have been instructed to submit before your Lordship the appeal may be heard any day. It is appearing in the list, daily list, your Lordship.
But that will cause delay in getting justice.
As item number 15, it was appearing
There
on
is no
6th.
interim stay order.
Learned counsel appearing for the alleged contemner submits that the connected appeal against the parent order is still pending before the Honorable before the division bench of the Honorable the Chief Justice and is appearing as item number 15 in today's list.
On 6th November, item number 15.
And appeared as item number 15 in the list dated November 6, 2024. What happened after that?
That was not called on that date, your Lordship.
So today it is not appearing in the list.
Today it is not there.
6th is 2 days back. So what is the current position?
After that, it is not appearing, your Lordship.
Why?
The Chief Justice takes up only original side and not the
It is
appeal
not
side.
in the list, but
Next para. Accordingly, thank you. Yes. Accordingly, it is contended, it is submitted that the contempt application may be adjourned for some time more in order to enable the alleged contemner to move the said appeal before the concerned division bench. Push up. Next para. The petitioner appearing in person submits that justice would be delayed in the event the matter is adjourned further. First of next para. However, comma, considering the position of the appeal in the list of the concerned division bench, comma, it would be inappropriate to hurriedly decide the contempt application without awaiting the fate of the said appeal. Push up. Accordingly, the matter is adjourned till November 22, 2024, when it will be listed under the same heading. Push up. It is expected that the alleged contemner shall move the matter urgently before the concerned division bench and furnish a copy of the order, comma, if any, comma, passed in connection with the appeal on the next returnable date.
Item number 11. Leave him. I am for the.
Yes, Mr. Saluddin, what is the?
I appear for the alleged container number 1.
This is the affidavit of rejoinder and reply.
What is the alleged contempt?
Pursuant to order passed by your lordships.
Yes.
Dated May 20, 2022. Your lordship issued rule. They appeared personally last occasion, and your lordship directed. They have filed also the.
What is the nature of content, Mr. Saluddin?
They have demolished the structure.
What was the direction of the court?
Page 23. On the basis of the rival contention, the respondent shall remain restrained till July
Changing nature.
of the orders.
After this, they have demolished.
Lordship.
This arises from what? I mean, just let us check.
Alleged contemners 1 and 2. 1 is the violated.
This was a bank sale?
Yes, this is the bank sale.
You are a third party to the proceedings. You have not preferred a challenge before the Debts Recovery Tribunal.
My lord, the civil suit is pending.
Civil suit? No.
It is the undivided property.
The bank took measures under section 13(4).
No, it is undivided property.
Bank took measures under section 13(4).
Yes,
the provisions of the West Bengal Cooperative Societies Act under section 122.
You took steps under that?
Yes.
Yes.
So why did you demolish? What is your answer?
My lord, kindly look at the order at the last page.
Yes.
Last page. On the basis of the rival contentions, the respondent shall remain restrained till July 15, 2022 or until further orders, whichever is earlier. So there is no order, my lord.
No, after July 15th, you have demolished.
May I assist your lordship, my lord? The contempt is against me, which is the purchaser after in auction sale. My lord, this writ petition was served on me, but inadvertently I could not have appeared. Thereafter, my lord, I have stated it in my reply to the rule. Thereafter, my lord, on receipt of this order pursuant to their letter of this solemn order, my lord, we have not taken any steps thereafter. Till such time, till the property was handed over to us and the receipt of this order, we had demolished a part of it, which have also appended photographs also to the reply, my lord. Thereafter, we have not taken any steps, and
yes,
my lord,
photographs.
There, I have filed on the last occasion a reply. File.
Yes.
By one Hakdar Ali.
Yes, partially demolished.
Yes, this demolition work was done by me during that interregnum when I had not received this order. After I had received this order.
When did you receive the order?
But on 13th of June 2022, I have pleaded at page, paragraph 4 of my reply, at page 4 of my reply, paragraph 9, 10. 8, 9, 10.
But you had notice of the...
yes, I had notice of this writ petition.
Affidavit of service shows that you were served.
No, yes, I say that. I had
choose not to appear. Then
what I was contending, my lord.
Like an ostrich. You put your head inside the sand.
No,
and you say, I can't see the enemy.
No, my lord. The fact remains that, my lord, these people were dependent on the bank, that the bank will fight the case out. Hence, my lord, we could not have appeared. It is an inadvertence, my lord. Thereafter, the allegation that my learned senior friend is putting, that on the September 2024, I have committed this error or whatever is the allegation. My lord, it is absolutely wrong. First, that I have already said that till such time I had not received this order, I had done it. because I had purchased it on auction sale.
But you say after 13th
After 13/6, I have not done anything.
36/22.
22. And, my lord, in my humble submission, my lord, the order passed by your lordship was an interim order, which they choose not to, my lord, extend, not to take steps for extension of this order. If at all I have done, that the order does not remain in the eye of law.
Which is what you are also submitting.
Yes, fine. Kindly look at page.
Yes, that is please.
But the
Paragraph of the
right.
contempt petition. My lord.
Yes, what do you say to that, Mr. Salahuddin? On both the grounds, it has not been extended. So after that, even if they demolish, nothing doing.
But your lordship's past order
For a
in
limited
July,
period. Limited period.
which will be
We cannot ascertain the date when he demolished or when he last demolished. Then no contempt lies.
We
If you
have-
did not,
we
if you
have
chose not
demolished-
to extend the order, then what can we do?
Entirely false statement.
demolished the
We have
structure
submitted, my lord.
started on 17th
Then
March 2024. My lord, if your lordship kindly come page 3 of my rejoinder.
Two things, Mr. Salahuddin. If they have started demolition on 17th of March 2024, there is no interim order on that date.
Yes.
Because interim order expired 2 years back. So they are not in contempt of court.
that is our submission.
If your allegation is that they have started on 17th of March,
Yes.
then
that
on the
is-
face of it, contempt does not lie. I shouldn't have issued a rule at all. Learned counsel appearing for the alleged contemner's content. You are for contemner number 1.
And I'm for contempt number 2.
2. Learned counsel appearing for alleged contemner number 1, who is the auction purchaser and bears the brunt of the allegations in the contempt application, submits that when the writ petition was taken up for hearing on May 20, 2022, and the order under contempt was passed, the alleged container number 1 was under the impression that the bank would be taking care of its interest and as such did not appear in the matter. Full stop, next para. However, subsequently, upon coming to know on June 13, 2022 of the order, immediately the little demolition work which was done in respect of the property in dispute was stopped by the alleged contemner number 1. Full stop, next para. It is further submitted by learned counsel for all the alleged contemners that the order dated May 20, 2022, in any event, expired on July 15, 2022 and was never extended thereafter by the petitioner. Full stop, next para. Hence, even on the date of the alleged contemptuous act, the order was not subsisting, and as such, it cannot be said that there was any contempt of the order of this court. Full stop, next para. Even from the submission of learned counsel for the petitioner, it is evident that the allegation of the petitioner is that the demolition work was done on March 17, 2024. Full stop. A bare perusal of the order dated May 20, 2022, passed in WPA 8592 of 2022, shows that the restraint order passed therein regarding the change of nature and character of the disputed property was passed till July 15, 2022 or until further order, whichever was earlier. Full stop. Since the order had long elapsed, even prior to the date of the alleged violation, it cannot be said that there was any violation of such order on the part of any of the alleged contemners or that any willful and deliberate contumacious action was undertaken by the alleged contemners. Thus, there is no scope of passing any penal orders against the alleged contemners. Accordingly, WPCRC 123 of 2024 is discharged and is discharged. The connected contempt application bearing CPAN 650 of 2024 stands accordingly disposed of. There was no further direction to personally appear.
No,
That was
my lord,
dismissed.
we have a dispensement. Thanks. Grateful, madam.
My lord, writ petition should also be disposed.
The bench which has determination, yes.
That is to be recorded, my
Why should
lord.
I have determination to take up the contract.
Grateful, Lord.
Grateful.
Grateful.
Thank you. Yes. Yes, Mr. Ghosh.
I am for the petitioner. I am appearing for the alleged contempt.
Cradle.
Cradle guard.
Yes.
But
Cradle.
we had served the notice as per the direction asking them to
experts.
Lord,
I think Lord,
they have
at
not
this stage-
conveyed anything.
At this stage, Lord,
Either
I think,
agreement or disagreement.
Yes.
I think, Lord, it is so far the expert is not necessary because of the case. Lord, your lordship knows, Lord, after long dispute, the division bench resolved the matter on the suggestion of the railways that they will place a cradle guard under the high tension line, which runs through over and Lord across our residential house. Lord, that was order was passed in the month of November 2006, and they Lord placed the cradle guard accordingly in the month of January 2007. From 2007 till Lord the early part of April 2018, it was all right. Cradle guard was there. In the early part of April 2018, it fell down. Lord, accordingly, we initially Lord met the authorities to reset it. They didn't. And ultimately, several representations were made, but no action was taken. And ultimately, Lord, they placed the cradle guard, but touching the roof. There was this direction that sufficient clearance should be maintained. That was not done. Lord, your lordship, we approached the writ court before your lordship, and your lordship passed the order. They didn't appear. Thereafter, they filed a review application that we have practiced fraud such and such. Your lordship has been pleased to dismiss the review application. Now your lordship can see that their stand in the contempt application is that we have raised the wall, therefore distance has been reduced. This is first. Second point is that cradle guard was never Lord fell down. Third point is that now they have appointed expert to measure the height. What is the distance to be maintained between the cradle guard and the high tension line? The 3 points have been taken. Lord, kindly see from the writ petition the communications from which it will appear. Even Lord, after this resetting the cradle guard, they have said that sufficient distance has been maintained by their letter. Now their stand has been taken that it was never fallen down. Now whether they have committed contempt or not, now whether it is.
Mr. Ghosh, we have to see two things as recorded in my order dated 27th of September.
Yes.
Which stands unchallenged. The two counterpoints are there. One is whether the disputed cradle guard is at all touching the roof, your roof.
Yes, yes.
And as to whether it is feasible otherwise, physically and complying with all governing principles, rules and regulations to lift the cradle guard further higher towards the high tension line.
Yes.
On these two, this expert appointment exercise has been going on since 27th September.
Yes.
So you had to agree on one of these suggestions or to bring your own expert. You could not bring your own expert.
Lord,
so you agreed to either of these, I'll appoint
Lord, so far expert is concerned, but your lordship can see their P, what they have taken.
No, Mr. Ghosh, there cannot be any compromise on expert. I cannot rely on your client's averments or their client's averments.
Because they are
either of the
contradictory.
clients.
No, Lord,
because they are contradictory.
No, I am not saying.
Rely on the litigants.
Lord, I am always ready that your lordship resolve the dispute by appointing an expert. But so far, whether it touches.
If you are ready, then agree to one of them.
But if it touches the roof or not, that is not necessary for appointment of an expert. Anybody, any learned advocate can go and see that whether it touches the roof or not.
There is another aspect.
Another aspect is height.
Whether it is feasible otherwise, physically and complying with all the governing principles, rules and regulations to lift the cradle guard further higher towards the high tension.
I am not further. I am telling you as
an
it
advocate
was.
cannot ascertain whether it will be
Lord.
possible to lift it
Lord,
so that no regulation is violated and it will be safe.
Lord, your lordship
advocate cannot decide that.
No, they are given Lord two names. Lord, they are the engineers of railways.
Well, I have given these names on 4th.
Yes, but here I can agree. Lord, your lordship kindly consider whether any independent report will come
You appoint somebody. I'm
That is
asking. I've
what
been
the-
asking you repeatedly to suggest a name.
Even
You have failed.
even before that date, your lordship had
Yes, before
passed an
that date
order.
also.
Yes.
You suggest somebody. He said, "I will."
On 23rd of August, I had passed that
Yes,
order.
yes.
Yes, yes, but that was, I could not at that relevant time, I could not, my lord.
No, what at that relevant time? For today we are in November.
Yes.
So for so many months after that, 3 months after that, you have not been able.
Then, my lord, kindly appoint one of them.
Choose one of them. Which name suits you?
No, I do not know anybody of them. How can I say? Your lordship, it is upon your lordship.
But you will have to bear the expenses of the expert.
Lord, expert is both. If it appears that they have not done so and it appears.
Then you will get costs.
No?
Then you will get costs. But it's your allegation. What should be remuneration?
That
Well, basically, their railway authorities, well, I don't know if they can take any, because it is their case, whether they can take any remuneration for the inspection. My lord. If there is any cost, special cost, my railways can raise a bill.
Fair enough.
Because
Then
my
a
lord,
counsel for the petitioner submits that in view of the nature of the allegations and counter allegations, comma, no expert need be appointed to hold inspection. For some next para, however, comma, it is seen that in the orders dated August 23, 2024, as followed up by the order dated September 27, 2024, comma, there were repeated findings of this court that expert is required to be appointed to ascertain the aspects involved in the contempt application. First of next para, accordingly, comma, since the petitioner has failed to bring forward any name of expert, but the alleged contemners have handed over a communication dated October 4, 2024, which names two experts, comma, who are officers of the Eastern Railway, comma, it would only be appropriate if one of them is appointed as expert to hold the inspection as intended by the court. Push up next para. At this juncture, comma, learned counsel for the alleged contemners fairly submits that since the proposed experts are employees of the railways, comma, it would not be appropriate that any further remuneration is granted to them apart from any necessary expenses, comma, if incurred in the inspection. First up, next para. In view of such fair stand taken by the alleged contemners, comma, Sri Sunil Kumar, comma, Assistant Electrical Engineer stroke TRD stroke Sialda within bracket South bracket closed, comma, Eastern Railway is appointed as an expert to ascertain as to whether the disputed cradle guard is touching the roof of the petitioner's construction and as to whether it is feasible otherwise, comma, physically and complying with all governing principles, comma, rules and regulations, comma, to lift the cradle guard further higher towards the high tension line which runs above the construction of the petitioners. First up, next para. The expert so appointed shall also ascertain as to whether it is now whether the present position of the cradle guard causes any safety concerns insofar as the petitioner's construction and its inhabitants, comma, if any, comma, are concerned. First up, a written report the expert shall hold an inspection with prior notice to the petitioner and file a written report on the next returnable date upon such inspection being carried out on the above points. First up, next para. When should I keep it? First week of December, first Friday of December. The matter shall next be listed on December 6, 2024 for further hearing and for furnishing of the report, which shall be filed through the learned advocate for the alleged contemners. An advance copy of the said report shall be handed over to the learned advocate appearing for the petitioners.
Lord, the other questions shall be kept open.
kept open.
Whether I have
It's closed.
construction, they have said that I have
Everything is kept open. Nothing is being.
Number 13.
Yes. Lord.
Lord, I beg to appear for alleged contempt, my lord.
Yes.
Lord, not sustain your lordship's order.
Why, sorry?
My lord, we could not sustain your lordship's order.
But we were directed to pay, my lord, to 4
I don't have any ownership of my orders. Very well. So, appeal will be allowed, setting aside.
Yes, my lord, the appeal order is there, my lord. Is there, my lord. We will hand over to your lordship, my lord.
Did not hand over, yes. Learned counsel for both the parties submit that the order, the parent order of which contempt has been alleged, comma, has been set aside by the concerned division bench, full stop. A copy of the said judgment and order passed by the division bench is also handed over in court and is kept on record. Full stop. In view of the parent order having been set aside, comma, there is no scope for sustaining the contempt application further. Full stop. Accordingly, CPAN 710 of 2024 is dismissed as infructuous. No rest to cost. Thank you.
Deeply obliged.
Item 14, Malam, appeal for the petitioner.
Yes.
My dear lordship, may kindly take your lordship's last order dated
Yes.
27 September 2024, paragraph 37. Your lordship will kindly would lordship find that
Yes.
they were supposed to file a compliance report on the returnable date, and an advance copy of the said compliance report ought to have been forwarded to us.
Yes.
But no copy of compliance report has been forwarded to us till date.
Yes. What? Why, Mr. Dutt?
No, my lord, I am assisting him.
No, man, Mr. Datta is assisting me, my lord.
Since you are appearing, you have to reply.
It is that matter your lordship may recollect where your lordship was pleased to dismiss the review petition.
Who is appearing for that?
And there was
Mr. Tanay Chakraborty, I think, and with Mr. Shuddhadev Adok.
Give a notice to them, Mr. Mojumdar. Let us come back on next Friday.
And my lord, your lordship will only kindly record that no copy of compliance report has been forwarded
Yes,
to
yes,
us.
I'll record your submissions and then only.
My
My lord, kindly give us a short date, my lord. Kindly give us a short date.
It cannot be shorter than 22nd because 15th
Absolutely,
is the
I
next
understand. I fully understand.
My lord,
I
one
fully-
additional my lord, information subject to leave being granted by Mr. Mojumdar. My lord, the incumbent has changed, my lord, the managing director of WBIDCL. So, my lord, the name
Yes,
has
now
to be.
Mr. Datta is correct, but previously it was Mrs. Roshni Sen. Now it is once again Mrs. Vandana Yadav. So, my lord, we may make the necessary changes, my lord.
You have to serve again then.
We had
My
in
lord,
fact communicated your lordship's order again to Ms. Yadav by
we have
a
done
business
that.
email and a letter. We have done that also
We
to
have
seek
done that,
compliance of your lordship's order.
Very well. When at the time of call, comma, none appears for the alleged contemner, comma, nor is any compliance report filed in terms of the order dated September 27, 2024. Full stop. Learned senior counsel appearing for the petitioner contends that neither has any copy of any compliance report been handed over to the petitioner. Full stop. Next para. It is further submitted on behalf of the petitioner that in the meantime, comma, the present incumbent in the post of the alleged contemner has been changed. Full stop. Next para. Hence, leave is granted to the learned advocate on record for the petitioner to carry out the necessary amendment in the contempt application by impleading the current incumbent instead of the original alleged contemner during the course of the day. Full stop. A copy of the contempt application shall be served on the newly impleted alleged contemner at the earliest, and an affidavit of service to that effect shall be filed on the next returnable date. Full stop. Next para. It is submitted by senior counsel appearing for the petitioner that in the meantime, the order of this court has already been communicated to the new incumbent. Full stop. Next para. Be that as it may, comma, the matter shall next be listed on November 22, 2024 under the same heading. Full stop. The learned advocate on record for the petitioner shall communicate a server copy of this order on the learned advocate appearing for the original alleged contemners, comma, who are also the review applicants, comma, in order to ensure compliance of the direction dated September 27, 2024 for the alleged contemners to file a compliance report with an advance copy to the petitioners. Full stop. It is made clear that despite the change of incumbents in the concerned post, comma, serious exception may be taken by this court on the next returnable date and orders passed accordingly in the event the said direction of this court is not complied with in the meantime.
Grateful, my lord.
Grateful, my lord, grateful.
By the alleged contemner, comma, alleged contemner stroke erstwhile contemner.
Grateful, my lord. Well, I take your lordships kindly, my lord.
Yes, yes, please. This is the third consecutive occasion when none appears for the petition at the time of call, full stop. Accordingly, CPN 881 of 2024 is dismissed for default. Next.
Number 18.
Lord, I appear for the petitioner.
Yes.
Affidavit of compliance.
Complied, Mr. Chakravarti?
Lord, they have
That has been disbursed.
they have paid the entire amount. Lord, I have a small request to your
He'll
lordship.
never be
Lord,
satisfied.
one prayer
Now
to your
they want
lordships.
amount of flesh out of what has
If
been
my
paid.
lord so feels, my lord, this is most humbly praying. They have paid the amount.
Don't care about my feelings. What is your
Only
prayer?
one thing is that the order was passed on 26 July 2023. And today we are, my lord, in November 24. Never preferred any appeal. When the writ was taken up, he gave undertaking that
Contempt cannot
everything will
grant
be paid.
interest, Mr. Chakravarti.
No, interest was not granted in the main order, but in this period, for this period, but my money has been kept by them despite an order of court, and the order was given on undertaking. The order was passed order, it was a consent order that they will pay. Despite that, 1 year, 6 months, I have been not kept loitering in court, had to spend money on the litigation. Lord, some cost and some interest should be paid to me, Lord. Otherwise, they will go on doing this every time.
Costs must be paid.
They will go on doing this every time. Because this is.
The 13 lakhs and all. That also has been disbursed.
But Devin, this is the calculation I have made. This is the calculation I have made. If my lord so feels, my lord,
An exception of 13 lakhs, which we found that it was difficult. There was some.
just have a look at
that
it.
also has been disbursed, my lord.
15th month, 15th month.
My lord, I beseech you.
So at the bank rate now, it should be 9,93,000 at the bank rate.
What about the delay of 1 year and so many
Yes.
months?
My lord, I understand. I request you.
And he gave undertaking.
My lord, that has also been disbursed. We are
There
not-
were
no more disputing that also.
There were 2 writ petitions.
So you had to prefer an appeal if you dispute it.
Yes.
My lord,
If you did not prefer an appeal, what is the fun of saying that?
I appreciate
No, you have to pay some
My lord,
cost.
I beg your-
Learned counsel
beg your
for the alleged contemner number
A compliance at a copy.
1. Alleged contemner number 1 files an affidavit of compliance which is kept on record. Full stop. Learned counsel for the petitioner submits that although the order of this court has been ultimately complied, comma, the delay in doing so was more than 1 year, for which the petitioner ought to be compensated by costs. Full stop. In view of the submissions of parties, such prayer is contested by learned counsel for the alleged container number 1. Full stop. Next para. It transpires that despite no challenge having been preferred to the parent order, comma, the alleged container number 1 committed a delay of more than 1 year in making the payments in compliance with the order of this court. Full stop. Hence, comma, although strictly speaking, nothing remains in the contempt application, comma, some compensation ought to be paid to the petitioner by way of costs by the alleged container number 1 for the harassment and delay suffered by the petitioner. Full stop. Accordingly, CPN 894 of 2024 is disposed of as infructuous by directing the alleged container number 1 to pay costs of rupees 20,000 to the petitioner within a fortnight from date.
My lord.
FCI represented, my lord.
Yes. You also, if you want to share in the spoils.
My lord, we did not give any.
It's like getting implemented in a contempt application. Please add me as a party in the contempt.
The desire of this.
Can such and such is accordingly disposed of as well.
My lord.
My representation will be recorded, my lord. I've been added by the, my lord.
Give your name at a bold letter, block letter, block kore bold de rahe ho.
Deep level.
Number 19.
19, my lord, I am for the.
Yes. New incumbent. You have served on the new incumbent.
New incumbent. No, incumbent service হয়েছে Services? Yes, I have received the affidavit, but a reply I have to give.
What about the appeal? Appeal was preferred.
Appeal was they have preferred before the wrong bench. I do not know whether it was deliberate or not deliberate, but just
Have you served on the new incumbent? You have to do
new
that also.
incumbent services.
Probably I did not direct you.
Yes. New incumbent. Yeah, new.
No, they were directed to
File
give the
affidavit.
particulars of the new incumbent.
Yes.
And you have to carry out the correction. You have carried out the correction. Serve in the meantime to the new incumbent, and I'll extend the time for filing reply.
Yes, madam.
On the prayer of learned counsel for the petitioner, the time for filing reply to the affidavit in opposition is extended for a fortnight from date. Full stop, next para. In the meantime, since a new incumbent has come to the post of the alleged contemner, the learned advocate, the petitioner shall serve a copy on the newly impleted alleged contemner. Oh, you have not impleted. I did not direct you to implement him. Newly impleted alleged contemner, indicating that the matter shall next be listed on December 6, 2024. Full stop. The learned advocate in record for the petitioner shall carry out the necessary amendment to the cause title of the contempt application by incorporating the name of the new incumbent in the post of the alleged contemner during the course of the day. Nothing else is.
Yes.
I am for the applicant, Lord. Madam, may I believe Lord filed reply, my Lord?
Opposition has been filed already?
No. I am for the alleged contemners.
Yes.
Order has already been complied with.
Complied with, Mr. Hadi?
May I submit this, my Lord?
But I have annexed
This opposition is this is not the complete opposition, my Lord. The learned chairman, the alleged contemner, they have not appeared. That has been filed on behalf of only respondent number 2. Contempt number 2, Lordship, my Lord.
No, I don't understand. I mean, what was the alleged contempt?
Alleged contemner, both were.
What was the order under contempt?
That was on 19th of February.
What was the direction given which was not complied?
Lordship kindly comes to my contempt application at page 14, Lordship, my Lord.
Certain time.
That was to be disposed of within six weeks, my Lord, from 19th of February 2024. That was to be by
now it has been disposed of but late,
my Lord.
So nothing remains in the contempt.
I am only submitting this, my Lord. This Lordship kindly go through the
to what?
Go through the resolution passed by the chairman, my Lord. May I sub?
15. Can we go into the merits of that in contempt?
My Lord, I only submitting this, my Lord, that lot of arbitrary and illegal things are there, my Lord, and due to that reason, my Lord, they are it has been recorded. May I read, my Lord, at page 16, my Lord, paragraph 2, my Lord, 10th line. As per as the board has occasion to consider the appointment of Mutawalli, and again resolution was adopted on 14th January 2020, whereby the board observed that since no rightful Mutawalli was available and the properties including the business of building the Waqf estate was in dilapidated condition, the board decided to appoint a caretaker, namely Mr. Ruby Ahmed, who is none else than the wife of the SM Murad, one of the descendants named in the Waqfnama. Waqfnama was executed in 1936.
The merits of this in contempt. You have to preface challenge them. Affidavit in opposition and reply filed today be kept on record. Full stop. Next para. It transpires that although belatedly, the order of this court has been complied with, and by an order dated September 25, 2024, the application of the petitioners have been disposed of by the Board of Awqaf. Full stop. In such view of the matter, nothing remains in the contempt application, and accordingly, CPA 936 of 2024 is disposed of as infructuous.
May I submit this only, my Lord?
Liberty is granted to the petitioners to challenge the decision of the Board of Awqaf, in accordance with law, if the petitioners is otherwise aggrieved against the same.
Already, the order against the order passed by the board, my learned friend clients challenge the said order before the tribunal which is pending.
Yes.
Grateful Lordship.
Thank
And I appear.
Yes, Mr. Oh, let's continue.
That the order has been complied.
Petitioner is not appearing. What was the nature of the order, Mr. Rai?
Your Lordship had asked us to revisit the issue. If your Lordship kindly takes page 16 of your Lordship's order of the contempt application.
But there is no reason of you have just
reason is what?
reiterated mechanically.
Mechanically,
This is an eyewash.
No, it has been, the decision has been taken, that decision has been communicated to them.
But you file an affidavit of complaints giving the entire reasons of this order. Learned counsel for the alleged contemner hands over a communication dated September 19, 2024 and submits that in terms of the order of this court, a fresh decision has been taken in respect of the registration as directed by this court. Full stop, next para.
Registration of additional qualification.
Registration of additional qualification as directed by this court. Full stop, next para. Although the said communication indicates that it was decided by the alleged contemner that the additional qualification cannot be granted to the petitioner, it transpires that the said communication is extremely cryptic and, without any further reasons to support the same, might border on an eyewash. Full stop, next para. Accordingly, the alleged contemners are directed to file a proper affidavit of compliance annexing the full copy, with reasons, of the decision taken by the alleged contemners as per direction of this court on the next returnable date. Full stop, an advance copy of the same shall be handed over to the learned advocate for the petitioner. Full stop, the matter shall be listed next on November 22, 2024.
I'll just
more.
Little more, yes, because from
December 6th.
Yes,
on December 6, 2024,
Great.
For passing further order. You'll have to give the reasons now.
Yes. Reasons are there with me, but
it's
not in that form. It is their note sheet, so it's better it is put on affidavit. I brought the entire file. But I didn't let it come formally.
Yes, they are not judicial officers, so they are not supposed to give
So
elaborate
what they
reasons.
did is, in the file they made a note sheet and then communicate.
Show me something that
Yes,
they
yes.
have adverted to that and
It is
apply
there
them.
just now.
I'll put it
on
on
affidavit.
Item number 22.
Yes.
May please, Your Lordship. On
Appearing on behalf of the contemner, my lord.
13 September, Your Lordship.
My lord, this is my opposition, my lord.
My Lord, I have just received it, my Lord. Few
I'll
days
reply.
time may be given. So
What
that
do you say in the opposition? Why did you?
My lord, in my opposition, paragraph number 3, my lord, kindly see.
they have taken contradictory stand.
But there is no any direction upon her.
Yes.
That is the contemner in the solemn order dated such and such. There was a writ petition to receive the amount in question, my lord.
But
Very well, file a reply and we'll
yes,
come.
yes. But they have acted contrary to that. They are caps.
An affidavit
My
in
lord, in the
opposition.
meantime, they have paid all amount, my lord.
So I will put it on affidavit.
Affidavit in opposition filed today by the alleged contemner be kept on record. Full stop. On the prayer of the petitioner, time is granted for filing reply till November 22, 2024. When the matter shall next be listed under the same heading.
I'm grateful.
23.
I am appearing on behalf of the alleged contemner, my lord.
Yes, Mr. Ganguly.
My lord, after the lifeline given by your lordship, my lord, we have complied with, my lord, immediately thereafter, after the last order.
Mr. Ganguly, can you give a copy of this to the advocate for the petition and come back on the next date?
Yes, it
We
is,
want to
ready
take
with
their.
us.
Very well.
Because
And
the entire amount, as has been directed by your lordship.
probably that is the reason why they are not appearing. But even
within
then,
3 days, it has been paid.
just keep the records correct. They give a copy.
My lord.
An affidavit of compliance is filed today by the alleged contemners. First of learned counsel for the alleged contemner submits that the order of this court has been duly complied with. First of next para, a copy of the affidavit filed today be served on the learned advocate on record for the petitioner by the learned advocate for the alleged contemners at the earliest. First of next para, the matter shall next be listed on November 22, 2024 for passing orders.
Grateful.
Thank you.
Item number 24.
My lord, I appear for the alleged contempt.
Yes.
I am for the petitioner.
What is the contempt?
My lord granted a stay order on 11th March 2024. My lord, that is at page 31 of the CPA. And that stay order has been extended from time to time. Now, what they have done, I'll kindly come to page 31.
One of the contempt.
31 of CPAN
Okay.
1311.
Yes, yes. Yes.
And
31.
the stay order was initially granted. The primary ground of challenge is the petition was blacklisted as a valuer of the respondent bank without adverting to the defenses disclosed by the petitioner show cause notice.
Till
And
30th April, yes.
subsequently, well, its stay order was granted. Subsequently, this order, interim order, was extended from time to time.
What
Now,
is the
what they
contempt?
have done, my lord, they have published a list on 19th April 2024, that is at page 34, excluding the name of the petitioner. Page 34 is the list they have published, excluding the name of the petitioner. Despite the order, they have what they have done cannot do directly, they have done that indirectly, and excluding the name of the petitioner.
Yes, what do you say?
My lord, first of all, my lord, the blacklisting was not done by us. The blacklisting was done by the South Indian Bank. Lordship, and the name of the petitioners, my lord, appeared in the caution list of Indian Bank Association. My lord, the Punjab National Bank only have de-empaneled the petitioner. They have published a fresh list, your lordship. There was no stay order upon publishing a fresh list of valuers. My lord, this matter is pending before the writ court. My lord, once it is decided, your lordship, and this empanelment, my lord, this does not create any indefeasible right. So, your lordship, there
Not
was
that, but till the writ petition is heard, there is a stay of blacklisting.
we have not blacklisted. We have just
No,
published
you
a
have,
list.
why did you exclude his name? He was there.
His
Unless you show us independently that you have taken out a proceeding and expelled him from your list on some other proceeding, there is no justifiable
my lord,
reason.
may I humbly submit it, my lord? My lord, this is the
If blacklisting is stayed, you cannot give effect to that. This is also a violation of the order of this court.
my lord, if may I say this, my lord, there are in each and every year, my lord, there are a list of valuers, my lord. Some valuers come and some valuers go. Well, just in the case of advocates, your lordship, that they are impaneled and my lord, they are not. My lord, they have published a new list. The name of the petitioner is not there because the matter is pending before the court. My lord, that is the only thing. A new list has been published.
Matter is pending. In the matter, we have clearly given passed a direction, passed an order of stay of the blacklisting. Then matter pending before the court cannot be a
My lord,
ground for order.
my lord, if that be the case, I'll produce on affidavit if there are any other thing, and if there is not, your lordship, then the bank will answer why have they de-empaneled the petitioner.
I have not directed affidavits in this matter.
No, your lordship. This is the first day appearing after the service.
Since a prima facie case of contempt has been made out inasmuch as the petitioner's name has been omitted from the list of impaneled valuers of the Punjab National Bank, despite an order of stay of the blacklisting of the petitioner, comma, the matter is required to be heard on merits, full stop. The alleged contemner, one contemner.
3 contemners.
The alleged contemners shall file their respective affidavits in opposition within 3 weeks from date. Reply, if any, shall be filed within a week thereafter. The matter shall be listed on December 13, 2024 for hearing.
Grateful.
Deeply
Item number 25.
Yes. Yes, Miss Ali.
Affidavit of service to the
You are for the alleged contemner.
Your Lordship's direction was at page 30 of the contempt act. It is the Pradhan he was directed to take appropriate steps with regard to an unauthorized construction standing in the way of an approach to a public library. Your Lordship remembers. And after a contested hearing, my lord?
They had not taken any step.
No, not yet. You are for the contempt?
Yes, what did you do in terms of the
we
order?
have taken the steps, my lord. My instruction is, my lord, on April, my lord, we sat for this issue. They appeared. Thereafter, my lord, in the month of June again. Thereafter, in the month of July, My lord, we have issued notice.
In the opposition,
both-
it's not there.
No, first time. The first time it is after.
What is appearing for the first time?
After the contempt petition has been served.
Yes, yes. Contempt petition, I did not give you any opportunity to file.
No.
Miss Ali, let them bring the documents on record, what they are saying.
I have given all these documents in my contempt application, stating that it is actually overreaching your lordship's order.
No. Last occasion they did not appear.
Very good, you come up.
Learned counsel for the upon hearing learned senior counsel appearing for the petitioner, this court is of the opinion that a prima facie case of contempt has been made out. First of next para, the alleged contemner shall file one contemner. Pradhan.
Yes, Pradhan.
The alleged contemner shall file his affidavit in opposition to the contempt application within 3 weeks from date, annexing all relevant documents, if any. Full stop. Reply, if any, shall be filed within a week thereafter. The matter shall be listed next for hearing on December 13, 2024. Please come. Affidavit of service filed today be kept on record.
Deeply obliged. এই কাগজগুলো লাগিয়ে
Item number 27.
Yes.
And later, Mr. Sarda, also new incumbent has come on list to container number 1.
So you have to implement them.
And two more prior before your lordship.
Pardon?
2 more prior before your lordship. It is engineering. Written.
Lord, I would be appearing on behalf of the alleged contempt. Lord. I shall use the affidavit.
Definitely, but
No,
First time,
you also have instruction to appear for the new incumbent.
no, that I know. Okay.
Which contemner you are appearing for?
কৌশিক
কৌশিক চন্দ্র ট্রান্সফার হয়েছে।
ট্রান্সফার হয়ে গেছে, yes.
নিরঞ্জন কুমার দাস এসছে 30 তারিখে হয়েছে এটা।
But till date he hasn't joined perhaps.
But it is your order is there immediate with immediate effect. You know, kindly have a go through this.
Learned counsel for the petitioner submit.
Before passing up,
Yes, yes. What are the two other? Yes.
Master, kindly go to the cause title.
Yes.
Cause title of the contempt. Page 7.
Page 7, yes.
The contempt number 2, he is not necessary party, his name to be expanded.
Right.
And third prayer before your lordship directed respondent 5 and 6, 4 and 5 to implement your lordship's order. That time that post was there, but no person was there. Now one in charge is there. I want to implement him. His name is with me.
Now one in charge.
In charge is there. I have got his name. I want to implement him as a respondent number 2 in place of respondent number contempt number 2.
In charge for which post?
Senior executive engineer. The
In-
chief engineer project. That is respondent number 5.
Learned counsel for the petitioner submits that respondent number that the alleged container number 2 was unnecessarily implemented and seeks leave to expunge the name of the alleged container number 2. Full stop. Insofar as alleged container number 1 is concerned, it is submitted that a new incumbent has joined in his place, and as such, necessary correction to that effect shall also be required to be incorporated in the contempt application. Full stop. Next para, further, learned counsel for the petitioner seeks to implement the incumbent in charge at present of the post of the respondent number 5 in the writ petition as a contemner in the present matter. Full stop. Accordingly, leave is granted to the learned advocate on record for the petitioner to carry out the necessary amendments to the cause title of the contempt application, thereby expunging the name of alleged container number 2, implementing the respondent number 5 in the writ petition, the current incumbent of the respondent number 5 in the writ petition as an alleged contemner, and to implement the present incumbent in place of the original alleged contemner number 1 in the contempt application. Such corrections shall be carried out during the course of the day. Copies of the contempt application shall be duly served on the newly implemented alleged contemners, and an affidavit of service to that effect shall be filed on the next returnable date. The matter shall next be listed on November 29, 2024 under the same heading. If you don't have instruction to appear for the new incumbent, then
My lord, sorry for interrupting, my lord. Thing is that, my lord, the name of the company, it has been changed because see, amalgamated, my lord.
Company is there.
Britannia Engineering Limited. Now it is known as Westinghouse XB Pharma Limited. Because, my lord,
Take out from the portal.
so I'll give that liberty to you also.
my lord, yes.
Further liberty is granted to the learned advocate on record for the petitioner to amend the name of the company of which the alleged containers are employees in the cause title of the contempt application. Do you know the current name? Give him the name.
Westinghouse XB Pharma Limited.
Tell him. Saxby.
Saxby, yes, my lord. Britannia Engineering, Westinghouse,
Right.
and Macintosh Bond.
Their
Three companies have been amalgamated.
notification about changing of the CMD also with me. From
So
the
carry out all the corrections. You'll have some handwriting practice now. Yes.
Item number 28, forward matter.
PW service we kept on.
আগেরটা ওটা add হয়ে যাবে affidavit of service.
Good, get
Quiz for respondents. Okay. Yes.
But I appear for DVC.
Petitioner.
But
Oh, DVC.
perhaps- Yes, perhaps Mr. Dhar would make his submissions today. So
Yes.
once Mr. Dhar concludes, my lord, your lordship may give me another date to make my submissions, my lord.
Very well. Very well.
Grateful, my lord, grateful.
My lord, on the last occasion, my lord had given liberty to file a 2-page additional
2-page?
additional written notes, my lord.
File it.
But I filed a very short
Yes, yes, you did.
4-page
Yes.
note. Would your lordship kindly?
This was your written notes of arguments.
But one additional point I had taken, so I said I will say, give a 1-page note.
Yes.
This is a 1-page note with just the regulation which I am relying on.
No, but this is 2-page note.
I tender apology.
Yes. Yes, Mr. Dhar.
Your lordship
Mr.
kindly-
Dhar's is also 2-page. 3-page. Yes.
No, mine is 4.
4, Raja. Very well. Yes, Mr. Dhar. What?
But I would not, I would try to be as short as my note. I shall make my endeavor.
Yes.
May I go with the note itself?
Yes.
And only I will make some submissions when, my lord, there may be little requirement. But these are the 5 things which are under challenge in the writ petitions. Your lordship, kindly take the first page of the note.
Yes.
So first is where I am concerned is they have sought that regulation 4.4, that is ultra vires. And second is, this is my lord, relatable to that, and this is one of the reasons for which they want to say that this is unworkable, therefore. Third is declaration that DVC acted arbitrarily, whimsically, and without jurisdictions by imposing regulation 4.4. This third is directly not, it has got no connections with the point of whether it is virus or ultra virus, because even if a particular law is made by me as intravirus, doesn't mean that nobody is going to abuse it.
Yes.
Now, fourth and fifth, these are absolutely, they have sought for
DVC has to answer.
DVC. So
Yes.
it's a basically calculation part.
Right.
As far as, my lord, I am concerned.
1 and 2 basically.
Yes. I have to satisfy your lordship that 2 things. Number 1, I have the competence to make such regulation. And number 2, this regulation is not violative of Article 14. Now, if your lordships kindly take the my note itself, the regulation, which is lordship might have noted while my learned friend made submission, so that is there at page 77. May I just place the regulations and thereafter, my lord, I would make my submissions. Well, as page 77, it is there quoted in my note, but there may be noting by your lordships. That's the reason lordship may take
Yes,
77.
yes.
If in a 15 minutes time block, a consumer draws power more than the restricted drawal, comma, if any, comma, imposed by the licensee, then the consumer will pay additional energy charge at a rate twice the applicable rate for that consumer at that time block. Such additional energy charge shall be payable in addition to the amount that is payable as energy charge for consumption of energy in that particular time block. Now, Lordship may first kindly the quote and unquote the difficult portions of the regulations. One is the restricted royal. Second is if any, because this is the submissions that this if any is completely unguided, because that's their entire submissions, that there is no guideline. And third is it is not done by the regulators, so I don't have power to delegate my power imposed by the licensee. To my understand, these are the, if I can say, these are the three areas of the regulations.
Twice is encircled here. I don't know whether
twice is the
Why
effect
twice?
of it. It could have been thrice, it could have been 1.5, but that's a calculation part.
All right.
But the petitioner is questioning the legality on the point. There is no guidelines, number one. And number two, it is not being done by the regulator, by the word imposed by the licensee. So meaning thereby, licensee has the power. Well, first I'm trying to make submissions which would be apparently against me, just to dissect it. Then only I may be able to, I will make my endeavor. So I find these are the quote and unquote the negative aspects in the regulation itself, to say that it hits Article 14 because of the fact it was not done by the regulator itself, because it says imposed by the licensee. Therefore, the licensee can impose restricted royal. And how that is to be done, there is a complete absence of it. And thirdly, this imposition by the licensee is without any power under the Act, empowering the regulator to delegate their power to the licensee. These are, according to my understanding, are the areas. Now, first is that Lordship will now kindly take my note itself. There are variety of principles which are laid down by the Honorable Supreme Court and the Honorable High Courts in variety of areas of our which actually touches us. Now, there can also be a variety of categorization, but if I just make a distinctions, that there are some field where the Honorable Supreme Court and the High Courts are concerned with the civil liberties, freedom of speech, no discrimination of religion, etc., which may stand on a separate field altogether, versus the areas which are more aspect of commercial in nature, some technical relating to financial aspects. What my endeavor is, yes, there are variety of principles by the Honorable Supreme Court while deciding how to decide whether Article 14 is hit or not. But while doing so, in which field that is to be applied is also one of the factors. For an example, if it is a case of someone's fundamental right to freedom of speech that is being violated, their parameters of the Honorable Supreme Court and your Lordships probably would be much more than if it is an exclusive domain of financial aspects involving technicalities and the commercial things. Well, I have said this for the reason, because I have seen also that if I go by just on the principles that it lacks the guidelines, then the direct answer would be yes, it lacks the principles. But if Lordship lifts the veil in a sense, can we put all the categories in one place and apply all principles everywhere? Or there can be a situations where a real-time decision has to be taken. Well, there is one thing, something is written in the textbooks and somewhere, and other thing, what in practicality happens. The regulatory mechanism is to see that the licensees, they supply electricity on A to Z principles in the Act. But it is not the regulator itself is actually dealing with the real-time factor. For simple examples, if here and now, if there is a technical fault of a load shedding or others, it's really not the regulator to come then and there on the real time to take care of the situations. Now it is the licensee, he has to have expertise and they have the technicalities to take care of that situations. My reason of saying this is that this entirety of the factor falls in the category of what to do in a real-time situations. This, as we say, that the flow of electrons, that in a large scale manner, the electricity cannot be stored. The whole nation, there is a grid that is required to be maintained on a particular frequency. That is understood by all the regulators and all the licensees, and they follow that. Now, there are some regulations like this, which regulations on the face of it definitely does look like not very fair, apparently. In a sense, why a consumer has to pay double the price of what is the tariff determined. But if Lordship looks at the overall aspect, then the other principle may chip into this, like some deterrent, some situations, which situations are exclusively in real time in nature. For an example, if a particular frequency in a grid required to be maintained, then no matter what the regulator says, it has to be tackled by the distribution licensee, generating company, and the transmission licensee.
Yes.
And if there is a fraction of a second, there is an incorrect act, my lord, there would be an havoc in the system itself. In that line, if Lordship may kindly take my note. My lord, first competence part, I would make submissions later on. Lordship may kindly take the necessity of such regulations for grid stability. If I can just read it first. Electricity generation and consumption must be balanced in real time, as electricity cannot be economically stored on a large scale. Excess drawal beyond a prescribed limit can destabilize the grid, leading to potential failures, load shedding, or blackouts. Regulation like 4.4 act as safety measures, compelling consumers to adhere to limits, particularly during peak demand periods or times of grid stress. Lordship may kindly mark the grid stress. As a regulator, I would never know where is the grid stress. This ensures that the grid stability is maintained, protecting the entire network from cascading failures. Need of discretion of licensee for operational safety. Well, I have used this particular term, that this entire operations being exclusively real-time in nature, I thought as a regulator that I should give a safety valve.
So you want to use this as a deterrent?
I want to use it.
Protect the safety.
I want to use it as a deterrent safety valve, which should never be a common phenomenon at all.
Then we have to look into proportionality. Then
yes, exactly.
Then whether it is.
I have answered exactly correct. That's a proportionality.
Yes.
Now, operational flexibility and real-time decision making, electricity and consumption are dynamic process that require real-time adjustments. The licensee, being at the operational forefront, is best positioned to determine the appropriate level of restricted drawal based on real-time grid conditions. This flexibility is crucial for responding to unexpected demand spikes or supply constraints, ensuring that the grid remains stable, that the electricity is distributed efficiently. Preventive measure, it's not punitive. The regulation acts as a preventive measure rather than a punitive one. By allowing the licensee to determine restricted drawal levels, the regulation ensures that consumers are discouraged from exceeding limits that could destabilize the grid. This approach is in line with what Lordship has just expressed, principle of proportionality, where the imposition of penalties is not to punish but to protect the broader public interest by maintaining grid stability. Licensees are tasked with managing electricity supply and demand within their networks, the discretion granted to them under regulation to impose restrictions and impose additional energy charge is essential for maintaining both operational efficiency and safety. Now on proportionality.
Now, Mr. Dhar, how does it operate? I mean, I am an end user,
Yes.
a consumer. I am using the electricity.
Correct.
When am I informed that this will be
now
15-minute blocks? I mean, how do I get to know?
May I say this? Well, 15 minutes blocks is the calculation purpose. Lot
All
may
right.
for the time being put it in the backside.
Yes.
How it operates.
Yes.
The words in the regulation is restricted drawal, if any, imposed by a licensee. Now, take the example of now. If CSC fills at say 340 is the time, and at 345 they are going to be such a demand, or they are going to be such a shortage of electricity to save the entire grid. We need to inform our big consumers that please restrict your drawal.
But is there any notice period? I mean, can they inform it 2 minutes before?
My lord, because that's the reason, my lord, I began with this. If the notice period concept is to be brought in, like 7 days, 1 day.
Not 7 days, even say
There has to
2
be.
hours.
There has to be, and I in my regulation there is a lack of it. I have felt
Otherwise,
it.
Mr. Dhar,
I do
what
understand.
will do is it will be entirely arbitrary.
I understand.
I say immediately, like saying that that you are polluting the water, that
No.
sheep and the tiger.
May I say this? First, I say that ideally I should have issued a guidelines that what should be the notice period, so that someone can act on that.
Otherwise, I can give 1 second even, theoretically.
Exactly. I just thought
I
about
penalize you. I said
exactly. I
penalize.
just thought about it, and that's why. So I was also thinking, yes, but that possibly may not be the reason also to throw the baby also with the bathwater. Yes, that can be done. That can be done by me, and ideally, in fact, I was telling to my friend also, but sorry, my learned junior also.
He's also your friend.
Yes, true. But I didn't actually had a discussion with you. Just I was telling him that personally I was thinking, why not there is a guidelines also to make it more transparent. I do say so, because I do say so, no doubt about it.
Because otherwise,
Because for little minute, not as a counsel for the regulator, as a counsel,
as a senior advocate,
as assisting your this honorable court, I feel on one hand there is a need of safety valve, number one.
Yes.
And number two is that this safety valve should be used as a safety valve and safety valve alone. Number three, that should not be allowed to be abused by any of the licenses. Like in this case, there are 7-8 licensee. There is no such example of any other licensee having abused it, but there is an example of DVC having abused. We enter into the picture of it, and we passed an order that he abused it, and 4.4 should not have been that. It should not have.
Your work is increased, in fact, if you don't put in a.
True.
But we are conscious of the fact that promptness is of the essence.
True. But
yes, it has to be done immediately, maybe, because otherwise the grid will fail.
Yes.
That we can appreciate.
But at the same time, when I try to, having said so, how I try to justify that to have this safety valve, yes, let me take the worst point that DVC has abused it. Does it mean that the safety valve itself is ultra-virus for that?
Say, Mr. Dhar, at the risk of not being an expert at all, knowing nothing on the technicalities, can this be a probability? I mean, because we can also read down legislations.
Yes.
So I am also thinking that.
Yes.
Can it be a probability to use as a safety valve?
Yes.
Immediately it can be done, even if with 1 minute's notice. Because if we see that it's emergency, it has to be done, it has to be done. But then for imposition of penalty, you have to give a notice period. I mean, suppose I say from the next minute you have to do it. But penalty will be imposed if you carry on after, say, 15 minutes. You put in the rider that yes, there can be a restriction, but that will not be penalizable.
Well,
You cannot impose penalty for a period.
Well, I personally feel that is an extreme fair way of.
Otherwise, because the grid will be saved, but for 15 minutes at least, they will not be charged for that.
True.
So, because that is the only way out I could find out when Mr. Chakravarti was
Well,
arguing.
in fact, I didn't say exactly in these words, but I myself was feeling that there has to be some time from information and action, because well, this is not a complete, it is not a prevention in a sense. Despite knowing, if he wants to draw, for an example, it may be a steel plant where he has to.
Yes.
He has to, because otherwise he may have more consequences, more damaging. So it's not a prevention that the electricity would be cut. That will continue. But then that continuance would be with a complete awareness of the consequence.
Yes.
And that requires some time.
Yes, that way you can also put in the safety aspect there.
I think I should not say a single word on that. That is
because otherwise,
true.
Because you are penalizing without notice.
True. But in the I am not aware about the exact fact of it, whether they got the 15 minutes or something like that.
In this particular case,
but I would prefer if there is a direction by your lordships, because sometimes what happens, the various authorities like a little bit of here and there nudge.
Yes.
It helps a lot. I was only thinking of this, if lordship finds it, no, this is a fit case where the baby is also required to be thrown with the bath water. Then that's a different thing altogether.
We maintained, but the bath water.
I was only thinking.
He hedged.
Yes. My whole endeavor also, I began with that.
Yes.
Because when my learned friend made, I would say, so well submissions, I listened to him.
He's floating.
I told him also outside that the couple of points.
Absolutely.
It's not because of the points itself. I felt that ultimately it would be good for the sector itself.
True.
Good for the sector itself, because tomorrow, if we have devastating things, my lord, it's not that. So if we have a sector where we have a safety coupled with based
Safety
on your
aspect
lordship's
has to
nudge,
be there. Safety aspect has to
based
be
on your lordship's nudge, some guidelines, I think there is nothing better than that. Somehow, my hunch was, someone was asking me whether I would take long time. I said, no, my hunch is I would be extremely short. Well, this last page 4.
Yes.
Basically, I need not read it out. I need not read that.
Reasonableness and proportionality you are reading out.
Yes, that I just proportionality in a sense that it's your choice. You don't get a complete cut and your whole industry gets shut down. It's not that. But you get a notice which has been declared by the licensee who is supplying the electricity that this is the situations. Please restrict your dryer. Don't put it at the 0. Restrict it. Now, you may take a decision. No, I don't want to restrict because I have another reason. So therefore, you have a freedom. So that freedom I was trying to interpret is this kind of proportionality, in a sense that it is not that information and thereby a prevention, no matter.
Your business is not being stopped.
Yes. So therefore, you have a choice, money, more money or less money.
But that would then, imagine the consequence then. More moneyed people will have the privilege of jeopardizing the safety of the grid. Whereas less, little operators, they would be, this is squarely Article 14.
This is, I would say, this is such a kind of, I would
say. In fact, it is already prevalent. Article 14 is on paper.
True.
Because, moneyed people can afford better counsel. Everywhere. Better doctors.
True.
I hope not better judges. Till now. So otherwise, because judges are whatever the council argue, basically. So if your argument is good, then the judges will deliver good judgment.
I was about to say this.
So the moneyed people are advantaged.
I was just about to say this.
Yes.
Today, lordships and we or every one of us are having a conversations and we are having some tools for that.
Yes.
Now, by dint of better logistics, if my tools get better,
Absolutely.
then other things are a very logical consequence. One is not robot.
No. True.
Now, well, as far as directions, I'm just repeating, but I just thought as far as any direction by your lordships to ensure number one, transparency.
But Mr. Bhot, that will be judicial legislation. That is
No, I'm not saying the lordship may kindly look at this.
only you can look at it. I mean the WBRC.
I'm exactly, that's the reason I'm saying the directions on the regulator.
We can give suggestions, but we cannot
Or
make
suggestions.
laws.
Well, my words may not be appropriate. I hope I have been able to.
Yes, yes.
I'm saying I've used the word nudge.
Yes.
In a situations where I'm trying to justify on behalf of my client that this is a valid piece of legislation.
In the form of guidelines, it may be put in.
Yes.
At least, let us, we will consider that.
My lord, I'm also required to, because not one substantial submission was made that under this act, Electricity Act 2003, there is no such power at all to delegate my power to anybody else. Now that is legally, it's an incorrect submission. Lordship has the Electricity Act here.
No, I don't have today. Thank you.
Kindly take section 97.
Yes.
Even without making any regulation, such power is there. But there is an exception. So before I place it, just I want to make these submissions. But there are some situations, some legislations where it is simply said that either you have a power to delegate your, either you have power to delegate whatever your functions to somebody else, or completely absence of it. There could be two categories, but there could be a third category, which is the case. You can delegate your power in all matters excepting two specific. So may I?
Limited powers.
Yes. So there are two things which have been prescribed. I can never delegate. Meaning thereby, by dint of this 97, I can delegate. This is my only answer to the legal point that it's
all right. All right.
The appropriate 97. The appropriate commission may, by general or special order in writing, delegate to any member, secretary, officer of the appropriate commission, or any other person. Lordship may kindly mark this, or any other, because the word person, it includes, subject to such conditions, if any, as may be specified in the order, such of its power and functions under this act, except the power to adjudicate disputes under 79. 79 is the power of a Central Electricity Regulatory Commission to adjudicate a matter between a licensee or a transmission company, or to refer it to the arbitration.
But this, Mr. Dhar, would be a very weak argument in the sense that you are then making the judge, the jury, the executioner the same person.
No, I say something completely different.
The delegation, you can delegate, but not to the
I have not delegated exactly.
Of the delegation.
I have not delegated. This is my legal answer.
You can delegate, but not to the beneficiary of the delegation.
May I say this? Well, first I say this is kindly detach from my earlier part and this part. There was a legal submission that under the Electricity Act 2003, there is
so you
nothing.
Can delegate.
I say 97, I can delegate.
Very well.
Well, there is also one judgment, unfortunately, by our court division bench. Unfortunately, I have not brought it. There, it was a delegation in a sense, no such delegation by any writing as is contemplated under 97. Similarly, by a regulation itself, some power was given. That was challenged and honorable division bench upheld it. Now, kindly put it there. I don't take help of 97 for the purpose of my 4.4 at all. Because I say 4.4 deals with a completely, because I have really not delegated the licensee on anything, because tariff is determined by me. I am not saying that I have delegated the licensee to do anything. I said that licensee is the only person, the distribution licensee, who will be having the knowledge whether there is going to be a situations where restricted royal has to be done or not, and nobody else. Lordship may kindly look at from real point of view. It is a matter of operational aspects.
Yes.
And that's a reason the exclusive, otherwise it will be paper, it may look good. The safety word it will have no value at all. Who will decide? For an example, today if I say as a regulator, I can say like what Lordship has suggested, 15 minutes time.
Don't arbitrarily decide. It depends on the facts. We have to be
Yes.
pragmatic on that.
Yes.
Regarding the safety aspect, yes. True.
So 97 is not an answer that yes, not at all. It was only because he said, I said.
Blanket
Yes,
non-power.
yes. I have not said that I am giving the power to the licensee to, no, not at all. That's the reason I have framed the regulation 4.4. And if Lordship looks at the history of it also, that I have not come across the abuse part of 4.4 by any other licensee. There are 7-8 licensees in the state of West Bengal. I have not come across for last, at least for the 25 years, this abuse of this.
The rest are state operators, all.
All are the state operators. All.
They
So they might
not
have
be efficient enough to.
either that or they realize the safety valve. Because I did say that there was an occasions by us, we had to say DVC actually abused it. I am saying it and I have repeated.
Or if there is some mechanism, Mr. Dhot, to make them answerable. Post facto maybe, but they have to justify in writing at least to the commission or somebody.
Well, there are two ways it can be done.
That
One
is
I feel, which I do feel, there could be a guidelines by the regulator regarding time bound or others, because then so that this penalty part starts after what timing.
Exactly.
That part there is a real lacking of it. Real time accepted, but because it is real time, it can't be one day, it can't be one, it may be 15 minutes or whatever it is. So but there has to be clarity that someone drawing, let us say at 4 o'clock, and information is given at 3:50, there has to be some time that he takes care of his own business and take a decisions either to go ahead or not to go ahead.
You tell him to do it in 10 minutes.
Yes, that's what I'm saying.
But he will be penalized after say half an hour.
True. I believe that the regulator should be happy enough. They should have done it themselves, but because of the reasons that there has never been, because there was a discussions on safety valve. Some my lord, the engineers who were in this sector for a very long time, they thought in their wisdom that we should have it.
No,
and
this evolves. The legislation evolves.
Maybe the other licenses, they have understood it so correctly, so they have never. It is like we use the pressure cooker. There is a safety valve also.
Yes.
I think none of us actually.
Imagine if you have to pay every time the safety valve goes off.
Yes.
You'll have to pay 10 rupees to them.
Yes. So safety valve, whatever is the meaning of it.
Yes. Let it be a safety valve.
Yes. All I say that safety valve should be there only for the purpose of safety valve.
Absolutely.
And to ensure that if anything is to be added, if anything has to be done, I think the regulator should do that. And of course, they would do that. And for that, whatever suggestions, whatever fallen from your lordships, they would definitely abide by that. But I don't think I have any submissions, excepting only one judgment, which I made. I need not, I have just quoted that. This was just to make a contrast that economic legislation versus, had it been a case of clear-cut civil liberties, those, then possibly absolutely bad.
Revenue, commercial, these are somewhat, commercial prudence has to be looked at.
True.
Yes.
These, I have mentioned it. There are paragraph 78, which I have not mentioned in my note. 78, what I said, my lord, exactly that was there, paragraph 78. That civil rights and then, so therefore propositions and the applicability of a principle, the field of operations is also a factor. And I'm relying on paragraph 80, which I have said, so I'm not reading it out. And
yes.
well, the all others, I don't think, because
Vasavi,
somehow I may be wrong, but I have a feeling that this is absolutely, as a counsel, I have a feeling that if there is, yes, my learned friend is right to say that there is some vacuum part, but if there is a possibility to correct it, as I said earlier, there is no requirement to throw the baby. It is possible to throw that part by doing that. But these are my respective submissions.
And Vasavi engineering,
But this is followed. That was, I just said I'm giving a copy. I just wanted to say that this 2008 judgment, that is also the holding the field, paragraph 23 of 2019, this has been also followed. But these principles are nothing new. So nothing that innovative things. So that's the reason. And all the judgments, well, I have seen, I'm not making any individual, because the judgments and principles are absolutely right. But the context, for an example, if it is, as I said, is it a fundamental right, civil liberties, or a municipal taxes? Those on a different context. But these are.
My lord, I will make my submissions on the next day, my lord, subject to lordship's convenience.
Third learned senior counsel appearing for the WBERC, full stop, for arguments of the DVC, comma, let the matter stand over till November 22, 2024.
Grateful, man. Great.
DVC should also file their notes, because DVC is the
Mr. Mujumdar, if you can please file your written notes of arguments on the next day,
so that I can
definitely, my lord. My lord, I will try to.
And if you
file
can,
my
you
notes.
can circulate a copy to Mr. Chakraborty so that
Certainly, my lord. Certainly, I will try to. But my lord, I think my submissions will be brief, because once the regulator has made submissions, my lord, I cannot make any submissions contrary to the submissions made by the regulator.
Yes, right.
Yes.
And you can only assure the court that you will not abuse.
Well, I can assure the court that I can say that I have not abused, I am not abusing, I have never abused, and I will not abuse.
Very good.
No, I have never abused is not the correct.
Never abuse is not correct, because WBRC has already cited a.
That is one instance, my lord. Those are corrective measures, my lord. But we will make our submissions. But I would not deliberate on this issue right now. We will make our submissions.
Very good.
I'm grateful, man.
Thank you.
Grateful, madam. Grateful.
29, yes.
That matter.
Oh,
Today,
invited this assignment to myself by passing the first.
and
So this has become infructuous.
Your Lordship, I have received
And
the
we have also
affidavit.
served
So I convey the message to the petitioners. And how many petitioners yet been received the flats? So, Your Lordship,
All of you have received.
no, Your Lordship. All of
Yes,
not-
Mr. Bose, you were saying something.
There's a chart for, my lord, one standard allotment letter you can find out. Any standard, my lord.
Yes.
See the last line of that. These are all allotment letters. And last line is, we do not have any claim grievances whatsoever with regard to the apartment. These are the possession letters. These are the possession letters.
They have signed.
Yes. Now, with regard to a chart, where to summarize everything.
Yes.
My lord, from page 111.
Yes.
If you find, now, my lord.
Who is left out?
Yes.
There are 100 petitioners.
99
petitioners.
My lord,
so all have been.
Oh, no. I'll tell you what is missing.
Yes.
My lord, item 6. Bhavna Agarwal, my lord, is the for her provision. This letter has possession has been handed over, but registration is missing. You will find, my lord, just come.
Number 6. 6, yes.
Page 111.
111.
Got it.
My lord,
Yes.
I'll tell you.
Yes.
My lord, what I have done is,
Handover possession, everyone, is the third column. And my lord, this is just, my lord, the deed number is the registration deed.
Yes.
After possession, some people. So Bhavna Agarwal, my lord, I believe she
Medical
is the daughter of the petitioner number 1, and medical issue, she has not done the registration but signed, my lord, the site because, my lord, some pregnancy or something like that, my lord. That's what I've been told. Huh?
The others have registered deeds and transferred the property and given
Yes,
possession.
yes. Come to 111. You will
Yes.
find everything filled up.
Ah,
Right. Now, my lord, only thing in Shanghamitra Das, item 44,
Yes, 44.
my lord, the lady, my lord, the first 2 documents email I showed you on the first day, October, she said I will be coming to take over handover possession
Yes.
on this day.
Yes.
My lord, therefore handover is pending. Therefore, I have left it blank, my lord. I have left it blank, she has said by letter. And my lord, before I come to the next page, 113, you will find everyone has signed, taken possession, registration deed, 114 also filled up, and Miller 115 also filled up, possession and registration. And then the summary is there. So handover done 98, registration done for 97, handover not done for 1, registration not done for 2.
We can take care of that, Mr. Bose, if you dispose of and you say that these people, whenever they approach you, you'll respectively register the document and hand over possession.
Yes, they have to pay the registration. You know.
Yes, subject to compliance by them.
Many people do not come because of.
No, when they approach you, within a limited period of that, you will.
Of course, I mean.
We can put that in my order and say that this petition will dispose of.
Yes, without.
Yes, what remains?
Your Lordship, 1 day adjournment, Your Lordship.
No, we have waited
Since,
sufficient.
Your Lordship, I have conveyed
This
the
is
message to
pending
the.
long back.
Yes, Your Lordship.
On 4th of October, it was last taken up 1 month back.
Yes, Your
more than
Lordship.
1 month.
I have conveyed the message to the Your Lordship, the petitioners, and I just received the Your Lordship, the affidavit, this reply, Your Lordship, and just day before yesterday. So this, Your Lordship, I have also conveyed the report, Your Lordship. So kindly, Your Lordship, I just for the instruction, Your Lordship, kindly give me a 1 day.
Lordship's order is there on the previous occasion. Now, my lord, if a matter is kept pending by, this is a public, not a public interest litigation. For other purpose, my lord, of course, no one likes a promoter. Now,
We'll put it on 22nd as I'll put in as a last chance. A supplementary affidavit is filed.
Well, there's some mistake, and
Yes,
I
happened.
beg to correct that. My lord,
Which respondent?
no, that's why I'm saying. If you see
Respondent numbers 8, 9, and 10.
8, 9, 10. Well, by mistake in paragraph.
In the caption also it says.
No, in paragraph 1, it
Yes.
is written. Because we were asked to file affidavit both in
There
the
and here.
appeal court and here.
The caption is also, it says
And,
appellant.
and my learned friend, I was not party. He has taken both.
Copy paste.
But even not done his job.
A supplementary affidavit is filed today on behalf of the respondent numbers 8, 9, and 10. Full stop. The caption of the same and the first paragraph erroneously mentions the said respondents as appellant. Full stop. Next para. Be that as it may, learned senior counsel appearing for the respondent numbers 8, 9, and 10 submits that in terms of the chart and the documents annexed to the supplementary affidavit, it will be evident, that barring 2 of the petitioners, the possession of the flats have been handed over and the transfer deeds registered in favor of all the other petitioners. Full stop. Insofar as serial number 6 in the chart at page 111, namely Srimati Bhavna Agarwal, due to certain medical issues, she could not approach the respondent numbers 8, 9, and 10 for the deed being registered in her favor, although possession has already been handed over. Full stop. Insofar as serial number 44, namely Srimati Shanghamitra Das is concerned, due to certain difficulties on her part, she could not contact the said respondents, for which neither the possession could be handed over nor the registration, not the transfer deed could be registered in her favor. Full stop. However, the respondent numbers 8, 9, and 10 are agreeable and willing to complete the formalities regarding the remaining two petitioners as and when they approach the said respondents. Push up next parallel, counsel for the petitioners seeks some time to take instructions from the petitioners. Push up as a last chance to the petitioners to disclose their version before the court, comma. The matter is adjourned till November 22, 2024. Push up it is made clear that in the event the petitioners fail to do so on the next occasion, comma, the matter shall be disposed of by this court in any event.
The subject matter repetition is we were not handing over. Now,
Over.
of course, they will have, I mean, bound to have some of them grievances against.
That is different. That is, maybe grievances regarding the area,
That-
other things. That is subject matter of something entirely else.
So, that is so even they are bound to come, and some of them, not everyone, no one bothers.
So that this court will in the within the scope of this petition, no.
Resistance যদি আসে if they approach. Regarding that money, your lordship was.
No. I said my lord has made it clear. If they approach,
If they approach,
with the money, naturally. I mean,
they approach and comply with the formalities only. Then.
Yes.
Great.
Item number 30.
It is that matter, if your lordship can recollect, where there was a provisional attachment. Your lordship by the enforcement director.
Settlement has failed. Settlement.
Yes, Lord, I had to give my learned friend, I had spoken to my client, I had to give an indicator, my lord, suggestion. My lord, the facts are this, my lord, that there are two brothers, my lord, Mahesh and Ramesh. Now, my lord, I am Ramesh. My allegations are against Mahesh. He has nothing against me. My lord, not a single complaint. I am Ramesh. No allegations against me. Under a family settlement, it is I have a lot of disputes with my lord Mahesh. There are large number of proceedings against each other. It is my case that under a settlement, a company, my lord Hanuman, has come to me, and Mahesh's shareholding has got extinguished. In that company, Mahesh's shareholding has got extinguished. Mahesh is also, my lord, pertaining to, my lord, banks, my lord, CBI, lot of history, my lord. So ED proceeds against Mahesh. But surprisingly, under the family settlement, Mahesh gets, my lord, a machine business, which he converts into his own company. That is worth around 500-600 crores. ED alleges that Mahesh is responsible. Mahesh, his wife, son. ED goes after Mahesh's business, but doesn't pass any order against Mahesh or its business, comes towards this company, which is, Lord, my company, and attaches 1/3 of the land. You're on the first
share in the
because Mahesh's share is still there. The CLB judgment, my lord, says that Mahesh's share is there, though his wife's share is transferred in my favor. So based on that, my lord, this argument. Now, my lord, spoke to my learned friend today. Our offer is that if at all you want to have any form of, if you want to attach, then go after, I'll give you all the information about Mahesh's companies. You examine whether if you have 600 crore company, which is the recipient of, my lord, this money, why do you have to, using a convoluted process of reasoning, have to get after my assets? So I can give him a write-up if he agrees to consider, and maybe he'll change his mind.
Well, what has happened, I tell your lordship in action. Your lordship interim order dated 26 September 2022 is detailed. Your lordship has found that so far as the property is concerned, which is standing in the name of the company, that should not have been attached. But the proportion share can be attached, that is under provisional. Your lordship granted a stay on that provisional attachment. Number 8, in the meantime, in view of the judgment of the Kaushalya
In the
infrastructure.
meantime, Kaushalya is considered in the interim order.
The final adjudication order has been passed, keeping it subject to outcome of the writ petition before your lordship. Now, what I proposed to cut short this writ petition, that since that is an order which is appealable in nature, there is an appellate remedy against that order. Keeping alive your lordship stay on that particular property, they can exercise their right of appeal. That is what I have.
So you wanted a disposal of the writ petition, keeping alive that stay order, making it absolute?
Making it absolute.
That stay till disposal of whatever
appeal comes. That is what I suggested actually. That let it not be, your lordship knows, under the PMLA Act, even after the attachment confirmation, property does not take over, cannot be taken over, unless the proceeding before the special court, the trial comes to a logical end, holding that that property is part of proceeds of crime and it is confiscated, so no question of taking over the property can come. Even in the judgment of Bijay Madanlal Chaudhary, it has been made clear, your lordship has held in other proceeding also, that no question of taking property, even possession, notional, nothing, no question. So make that stay absolute till the attachment and confiscation reaches its finality.
Mr.
That stay,
you can consider this proposal.
That's my proposal.
Next
That
Friday I'll
proposal
come
is my
back. I'll ask my client, but in all probability, I'll proceed, my lord. Since my learned, I'll also give him something in writing for him to consider.
Do
Yeah,
that in
I'll
the
also
meantime,
consider
because
this.
in 14 minutes, if you take up the matter for hearing,
Yes,
it
there's
won't be
no
over.
time.
No.
So uselessly, why should you start? I mean, let us come back then, explore all the opportunities
And then on the next day we'll do it.
22nd we'll
I
have.
propose that in writing.
Oh,
to
next
my
Friday is a holiday. You need not. You bole diyecho.
Well, 22nd, I have some personal difficulty.
29th then?
29th, my lord, would be
Grateful.
In view of the possibility of settlement being still alive, let the matter stand over till November 29, 2024 to enable the parties to explore such opportunities in the meantime. Full stop. In the event the parties fail to reach any settlement, comma, the matter shall be taken up for hearing on the next returnable date.
Grateful.
Item number 31.
I am appearing on behalf of the respondent number 2 and 3.
Yes, you appeared on the last occasion. Oh, 2.
Yes, 2 and 3, my lord. District Primary School Council, not just forum.
None appears for the petitioner at the time of call, although the respondent numbers 2 and 3 are represented. Push up, let the matter stand adjourned for the day. For the day means Friday week, 22nd it will.
Item number 32.
Yes, some report was sent by the state in this matter. That
matter where my lord guardian was appointed.
Yes. There was a report probably from the concerned department of the government.
What happened, my lord? We had been filing our compliance report. They had said in their reply to their compliance report, you have to give details of properties, documents, and everything. We said order didn't say that we have to give.
Mr. Lahiri, can you give a notice to the state? Because
I have already given notice. Affidavit of service is filed. I have given notice to the department. Nobody appears. My lord, on the last occasion, my lord directed the matter to be served upon the government pleader. The office of the government pleader says disposed of matter, we cannot take service. Or we have tried to serve 2 copies of the umpteen number of times we have gone to the government pleader. Personally, my advocate on record went. I have been complying. My compliance report has also been filed. We have not dealt with the property. Only last August we had sold 1 property after filing of our compliance.
So I'll direct this matter to go out of the list.
Let it go out of the list.
Out of the list with liberty to the state to mention.
To state to mention upon notice to her.
Definitely. Despite repeated service of notice on the state through different instrumentalities, including the Department of Women and Child Development and Social Welfare, Government of West Bengal, the state remains unrepresented when the matter is called on for hearing. Full stop, next para. As such, comma, no, as such, no. It transpires that although the writ petition was disposed of long back, comma, there was an observation in the order of disposal to the effect that in the event there is any discrepancy in the reports filed by the petitioner, comma, the Department of Women and Child Development and Social Welfare shall place the matter in writing before the Registrar General of this court, upon which the matter shall be placed before the appropriate bench. Full stop. Upon such a communication having been made by the said department to the Registrar General, indicating some purported discrepancies in the report filed by the petitioner, comma, which is also on record, comma, the matter was taken up by this court. Full stop. However, comma, as narrated above, comma, despite several opportunities, the state fails to appear and present their case before the court. Full stop. Hence, comma, there is no other option but to relegate the matter out of the list for the present. Full stop. Accordingly, let the matter go out of the list with liberty to the state to mention the matter for inclusion in the event any development takes place. Any further development takes place. It is made clear, however, that the petitioner shall continue to comply with the order passed in the original writ petition.
I've been complying. Only with prior notice to the petitioner.
আচ্ছা, liberty to mention যেখানে বললাম, with prior notice to the learned advocate on record for the petitioner.
Obliged.
Thank you.